It is in the list.
Yes, combined monthly.
Which number?
My lord, 780.
My lord,
780.
my lord, may I be permitted to mention? Acha, sorry, sir.
What is the number?
Item number
Nice. WP number?
WP at
28170.
Rosula Bibi?
Yes.
Recorder note. Though the matter is listed as in the monthly at item number 780 in the monthly list, but the land counsel for the petition mentioned the matter and submit that this court is not having the determination, and he prays for release of the matter with the liberty to mention before the appropriate court having determination. But the land counsel for the petition WPA 21870 of 2025 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
My lord,
My lord, my lord, may I be
your lordship, in connection with the ED matter, pass this order, but my main name is missing. At 1 p.m. the order was passed, my lord.
Calcutta, okay then? To be mentioned?
May I have lordship's kind leave to mention a matter, my
My
lord.
lord, may I be
Agencies have been removed from directorship, and the form to the DI 12 has been accepted by the ROC in contravention of the rules and the section 169 of. Now they've given effect to that I've come to know on 21st of July. The company is entering into another arrangement, my lord, where I'm a director of that company. If the returnable date is 31st, if it could be either taken up tomorrow or on the 31st at any time, lord.
Why are you filing
It's covered by a lordship decision.
Why are you filing all writ petition? Go there. Commercial court and company court and
This way, I can't go to company court. I'm not a shareholder. I'm just a director of the company. This will take 5 minutes, right? I'll actually seek for a consideration of tomorrow.
It is not listed.
No, my lord. It's been filed. If it could appear tomorrow.
Friday for the
Friday.
my lord,
Very
Lord,
good.
my lord, may I be permitted to mention, my lord?
Lord, he's there, Lord.
Yes, my lord. My lord, my lord, relating annual puja, which was occupied by a unauthorized person, my lord. We are not able to enter into that premises, and we have to do the puja, my lord. So we're seeking permission from police and the municipality. Nobody has helped us, so we filed
This
the
court is neither having the determination of the police or the municipal authority. This court cannot pass any order. Go to the court which having the determination of the either police or the municipality. This court cannot do that.
Lord,
Come,
So, my lord,
come tomorrow.
kindly be
Lord,
released.
tender for maintenance of transformers issued by WBSCPCL.
Yeah, sir,
But the criteria is that bank guarantee has to be filed. I submitted online the bank guarantee. I uploaded. Posted physically by 9th of July. I
Lack of
bank guarantee was uploaded online physically. It's not like it's a huge contract. They will register the vendor and give the work. So I was the existing vendor. The bank guarantee was mine. It was uploaded mine. Only physical copy we could not deposit on that day. Late by a day, I made a representation on 13th. They have
When
rejected
the
it.
financial biddies will be open.
But it's not financial, it's a maintenance contract. Rate is fixed by them. Several contractors will be enlisted and they'll be given work. So I am out of the picture now. Only if my technical bit is through, I am through. The rate is fixed as far as my instruction goes. And bank guarantee was made. It's not a case that I was not ready with the bank guarantee.
Which department?
The WBSCDCL, West Bengal State Electricity Distribution Company Limited.
So
It's a tender matter, so I will come back now once your lordship allows me to come back.
come on Monday.
Monday, as your lordship pleases.
My lord, kindly be
But maybe
Leave is granted to file with the notice to the authorities. List on Monday within 10 minutes.
well, I'm grateful.
10 matters.
Yes.
My lordship indulgence to mention a matter. My lord, I am a student of civil years. I have to go to abroad for higher studies. My electoral loan it has been abolished. That no electoral SIR matter. If your lordship kindly take up this matter, any day, your lordship. I'm students of St. Xavier's. I have to go to abroad for higher study.
When you
And
file
then
the writ application,
My lord,
when you file the writ application,
when
you file the writ application,
3 weeks ago.
huh?
3 weeks ago.
3 weeks ago, every day minimum 10 to 20 advocates are mentioning the SIR matter, and this court is taking the SIR matter on Friday at 1 p.m. About 70 matters I am taking the SIR 1 p.m. You're not aware of that. Only you are aware that a court is taking every day mentioning this, come and mention the matter. And you went to the cause list, come on Friday, we'll
Then
see that.
I'm paying apology.
Friday roko.
My lord,
Come, today is not the mentioning day. Come at 3 p.m. before rising, I will extend that.
my lord, kindly.
उनको क्या देखो उनको बोल दो ना determination नहीं है.
My lord, I am praying for release because the matter was not listed still now, my lord.
Tell him that this court is not having the determination,
এই ঘরে
so
আসার
cannot take the matter.
না আমার ফাইল করা ছিল এই ঘরে রেতে 27 তারিখে আসার কথা ছিল।
Release.
তারিখে।
लिस्ट আছে কি?
না
कल का लिस्ट कर, हाँ लेके कल टू बी मेंशन करो रिलीज के, हाँ नতুन फाइल कल के लिस्ट करो.
Lordship,
Weekly approach, my lord.
Lordship,
Yes.
under the compelling circumstances, Your Lordship, I'm mentioning this matter upon notice, Your Lordship. Since Your Lordship, the petitioner's name has been removed from the electoral rolls. He filed the petition, Your Lordship, 3 months ago. But Your Lordship, due to the removal of his name from the electoral roll, his passport that has not been renewed, Your Lordship. That notice has come, Your Lordship, from the passport authority that to file, Your Lordship, the appropriate data and including, Your Lordship, mentioning the fact kind, Your Lordship,
तो ले लो
it will
कल
take
रख
it.
दो SIR मैटर कल रख दो. Yes,
Grateful.
call the list.
Question one matter. In NLM guidelines, the central government had released a scheme of building entrepreneurship by giving loan. So our client had a project, we had a project of 1 crore 28 lakhs. He had submitted the project.
So what is your grievance?
The grievance is, my lord, everything is passed. The project has been sanctioned. The loan has been disbursed. I mean, 14 lakhs loans has been disbursed. Now bank is telling I can't give any other loan. Central is not giving me any other direction. At the same time, the petitioner has to give EMI of the loans. The EMI has started.
So what is your prayer here? What is your prayer before the court?
Lordship, the appropriate prayer is I want the loan to be finally disbursed so that I can start off my business.
Whether the court now the court work is to give the loan,
No,
sanction the
I
loan.
just want the central government to be directed that they can tell the SBI to pass. I mean,
What is the urgency in that? Yes, call.
urgency is, my lord.
May I permit you to mention one urgent matter, Your Lordship?
Come, all mentioning come tomorrow, Thursday, I will take matter. Yes.
One urgency, my lord, under the Senior Citizenship Act, my lord, I am out of this.
Come tomorrow. Tomorrow is the mentioning day. Come tomorrow, I will take. Yes. Which was number one? Who is the number one?
I am here. Kindly have a look to this letter from my client. I want to withdraw. Why? There's the reasons.
Mr. Banerjee wanted to take the matter from this court and withdrawing, and that too withdrawing.
Actually, my authority has assured. I just told you earlier, my petition is pending. And I
My lord, I appear for WB Hitco, my lord. There is no assurance from the authority of any nature whatsoever, my lord.
I made a representation. And that is
My lord, there is no assurance, my lord. What we have been instructed is if they let this, if the writ petition is treated as a representation, well, then we can
Withdraw.
consider. There is no.
Any order for consideration. Yes. Yeah. At least this has to be mentioned as per the prayer made by the counsel for the
Sorry to interrupt, my lord.
and counsel appearing for the.
Sorry to interrupt. He submitted, let the writ petition sent to us, we'll consider. Very well, I don't mind.
Keep rolling. For the petitioner handed over the written communication wherein the petitioner has requested an advocate to withdraw the writ application. In view of the communication, the counsel for the petitioner prays for withdrawal of the writ application. consider the submission made by the counsel for the parties and the written communication. WPA number 4936 of 2026 is released from, is dismissed as withdrawn. Communication be kept with the record.
So, my lord, the petitions to be considered. They claim, if they
I'm
send it,
You write the letter and tell.
as I've already sent it, my lord. Anyway,
Did-
I'm trying to tell you, my lord.
Yes, next.
I'm so grateful.
Yes.
The interim order is expiring on 30th.
30th, tomorrow.
You will kindly extend the interim order, and Milord, it's your lordship, Milord, had heard the matter on a number of occasions.
That
Yes, that,
contact has not been, acha, there is an interim order. Yes, what is your instruction? Take instruction because he wanted to complete the work, you wanted to go for the due tender. So sit together, if he is ready, put the condition and complete it.
And that's
Take
all.
instruction. The matter list has to be mentioned for extension of interim order. And land council for the previous summit, the interim order is till 30th and paid for extension. For the land council for the parties, interim order is extended till 28th of August 2026 or until further order. Let the matter appear on.
If it can be fixed under the head to be mentioned so that the matter can be disposed of.
But they have to take and let the matter appear
I'll
on
leave it to my
13th of August.
I'm grateful.
13th under the heading urgent motion within 10 minutes.
I'm extra. Thank you, Didi.
Bank of India, Mr. Debashish Shah. Milord, I am here for Bank of Maharashtra. I have filed, Milord, a vacating application, Milord, for the vacating of the interim orders.
Vacating of interim order.
Yes, Milord.
Respondent number 4.
Yes.
Still be, my lord.
For
Still developer Bank of India. my lord.
My
You-
lord allows me, Milord, I want to place, Milord, 2-3 things.
Please go.
Milord, my learned friend filed a writ petition. Milord, challenging, Milord, our notice, a pre-NPN notice issued by, Milord, my learned friend, Bank of India. Now, Milord, in that matter, Milord, we were tagged. Bank of Maharashtra, Milord, we were tagged. Milord, we were made a party. Now, Milord, we have not issued any notice. This is first. But an order is passed against all the banks so that we cannot take any steps for declaring the account as NPA or for further, Milord, taking steps for non-payment of dues. Now, Milord, what is the case made out by my learned friend in the writ petition? That look here, and proceedings is pending with the enforcement directorate. Now that was challenged.
now
before-
what is the order of before the honorable, what is the order of the honorable Supreme Court?
Yes, my lord, that is interesting, my lord. I am coming to that. My lord, kindly come to the Supreme Court's order. Lord, that was a vacation bench, my lord. Now, my lord, the vacation, my lord, that order has been placed that the regular bench, the matter has been given before the regular bench, my lord. That's why, my lord, I have filed it. If my lord says that, my lord, that bench will hear my matter, my lord, I have no other difficulty then. But kindly, my lord. Yes, my lord.
57. There shall be a stay of further proceeding indicated earlier order passed by the SLP. Meanwhile, the operation of the order.
Support করছো।
My case is not same as.
But this is a matter regarding adjudicating authority. Yes. Adjudicating authority.
My lord, I am not for the adjudicating
So,
authority.
What you are appearing for whom?
My lord, I am appearing for Bank of Maharashtra.
So how you are affected with the order?
Because, my lord, kindly see the High Court's order, the Honorable Supreme Court's order, page 58. Meanwhile, operation of the impugned judgments and order dated 17/10/2025 and 3/11/2025 as well as that of the learned single judge order shall remain stayed. My lord, order against the, my lord, the proceedings which is with the enforcement directive that has remained, that has been stayed.
Correct.
My lord, how can, my lord, we We were not a party to those proceedings.
Correct.
And my lord, how can we be restrained from declaring our accounts and NPA on due to non-payment of the dues by them? Lord, those both are completely separate.
Then have you filed the affidavit of the application? Vacating?
My lord, kindly come to.
So, okay,
two pages.
then I have to hear that your application.
Yes,
Okay, I
sir.
got your point.
Yes.
But the court has to hear, then the opportunities to be given. Let the file affidavit. How soon he'll file? 7 days. Let the file. You
My lord, only two things, my lord, just my lord, for.
I appreciate. I understand you, Matt.
My lord, I appear for respondent number 4, another bank, my lord. I am, my lord, because of non-payment, the bank proceeded to
NPA.
declare it an NPA, my lord. Now, my lord friend says the bank account from which the payment was supposed to be made was initially frozen by the PML authority, and eventually which order has been stayed by the Supreme Court, my lord. Now, my lord, fact remains, my lord, they have defaulted. My lord. They could have paid from other accounts, so they have taken loan. So bank cannot be stopped from proceeding under the SARFAESI Act. But I also would appear and join prayers, my lord. I intend to file an opposition, my lord, and before submitted, I shall file it, my lord. Kindly give me 2-3 days, I'll file.
File a opposition to the writ petition, my lord.
My lord, I am appearing for Bank of India, respondent number 2, my lord.
Yes.
Respondent number 2, my lord. This account has got no connection with.
Complete.
I think-
Complete the affidavit. Pleading
I think
with
Mr.
regard to-
Bhujbal's submission, my lord, I agree with that. If the writ could be disposed of, my lord,
This will be
stated.
disposed of.
application has to be moved, it will have to go before the.
Yes. So let's move the
Correct.
writ petition and argue our respective cases.
Though the matter is listed as to be mentioned for the on the prayer of the petitioner for extension of interim order. Land council appearing for the
Bank of Maharashtra.
My lord, Bank of India, I am appearing for Bank of India, my lord.
Bank of Maharashtra submits that he filed an application for vacating of the interim order. The other London council appearing for the other banks also paid for vacating the Vinci interim order. Full stop. This court find that instead of hearing the application for vacating the interim order, the writ petition is to be disposed of only after exchange of affidavit. Let affidavit in opposition be filed within
My lord, 1 week.
1 week. Reply, if any, there to be filed within a week thereafter.
But there are so many opposition, please give us 2 weeks.
Within 2 weeks. Full
My lord,
stop.
in my case, I would require 2 weeks, my lord. Because some of the officers are in Bombay.
Position of the writ application within 2 weeks. Reply, if any, there to be filed within a week, within 2 weeks thereafter. List the matter on 28, 29, 30 August. List the matter on 3rd of September 2026 under the heading adjourn motion within 10 matters.
DP office.
Urgent motion.
The interim order to extend it.
Interim order is extended till the next date of hearing or until further order, whichever is certain.
My lord, item number 4, I am appearing on behalf of the respondent number 4. My lord,
Yes.
My lord, we have been briefed by our client yesterday only. Kindly allows us time. We'll file the wakalatnama in the course of the day. And we are also taking an exception as to the maintainability of this writ petition, my lord. Kindly allows us to file an opposition.
You are appearing for whom?
The respondent number 4, my lord.
Respondent number 4, SBI.
Yes, my lord.
My lord, I appear on behalf of respondent number 5. I also require 2 weeks time to proceed with the matter, my lord. We will also file our wakalatnama during.
Yes. What about the 1, 2, 3? 1, 2, 3, nobody is appearing.
My lord,
1, 2, 3. IBC and Deputy General. Yes.
we are not aware. We
Yeah.
are not aware about them.
First party is not here.
Five.
Company in liquidation.
For one, it is not served.
Now, there's been not please,
Yes, it is not delivered.
but deliver. I think there's been now received by them.
So when you will come? Interim order you are paying for
Yes,
it?
my lord, because the order has been passed, no order, it has been published on the website. Your lordship kindly come straight away to the page 102. Yes, this is the publication made in the website,
Suspended.
suspended, and that too without hearing without passing any revision order. And your lordship can see, most important factor is this, when this designation chapter comes before the learned NCLT, then it has been submitted, page, your lordship can see 93, not 90, sorry.
93 IBC order.
Sorry, your lordship can come page 49.
Yes.
Page 49. Yes, your lordship can see. Learned Council DN Sharma submits following companies, 4 companies under same promoter are various things of insolvency. The company Padmavati, MP Coke and Mahalakshmi Corporation. Learned Senior Council DN Sharma assures that the show cause notice upon the definitive will be unconditionally withdrawn by SBI. Thereafter, they have proceeded. IBI. Well, may I put this question? How can it be possible? And moreover, the reduction of the share of the SBI is pending before the NCLT since 2025. No decision has been made. You will be interact now.
So who are you?
I am the liquidator.
You are the liquidator.
Yes. My license has been suspended. My authorization has been suspended. And that too in violation of
Authorization has been suspended by whom?
by the
IBC.
And it has been published in their website.
My lord, may I make a submission? My lord, at the very outset, we would like to submit that the respondent number 1, IBBI, who is the main answering party over here, its office is in New Delhi. So at the very outset, this very humbly, I would like to submit, my lord, that this honorable court does not perhaps have the jurisdiction to decide this and the instant writ petition. And secondly, my lord, there are several judgments.
The matter, I will take the matter. If you argue, then I will not adjourn.
No, my lord.
Once you are asking the adjournment, then you take adjournment. If you wanted to argue the matter on the point of mentality, I will take the point of mental hearing now, and I will decide it.
My lord, kindly allow us to come back, file the wakalatnama opposition. My lord, 4 weeks, 3
They
weeks.
are asking for the interim order.
Kindly allows us 2 weeks, my lord.
No. Filing wakalatnama only I will give by Monday or Tuesday, nothing else.
My lord, kindly appreciates we have been briefed in this matter.
My lord, another
Then
moment.
you argue the matter. You receive the notice. If you're not appearing, then
My lord, I'm taking.
My lord, kindly allows us.
time maximum Monday or Tuesday
My lord.
with regard to the interim order.
My lord, my client comes to send me the wakalatnama from Delhi, my lord. If
No problem.
Yes, my lord.
I will give my website. Bring the wakalatnama through website.
We will get it
Yes,
in email,
so-
my lord. If my lord fix it on Wednesday, it is possible for us, my lord. Wednesday would be good.
Remember, I need certain protection up to.
That's why they are asking the interim order, and this court, after taking into consideration, has fixed the matter as item number 1 today.
But I understand that there has to be an urgency. They are definitely asking for an interim order, my lord. We have not.
As per the prayer made by the counsel for the respondents, let the matter appear on 5th of August 2025 under the same heading within 5 matters.
Grateful, my lord. My lord,
Affidavit service filed by the petitioner be kept
My
in
lord,
the-
in the meantime, up to 6th of August, you also can give me little protection. Up to 6th of
Come on 5th August. I will,
up to 6th of August. I am not asking anything more.
come on
This
5th.
order has been
I will hear on 5th August. They will not raise.
My lord,
My lord, submission?
one thing. May I respond to your submission? My lord, I am appearing with him.
No, we are not doing the hearing now.
The very fact of the maintainability, which they are the same matter, on the same issue. I'll place a judgment on Wednesday. Justice Parashinda Gaurav of Delhi High Court has considered the same issue. Probably my learned friend is not aware.
Come on, that's why keep
Very well.
within
Every-
5 matters. I will hear.
Yes.
Like every matter, if a head office is Delhi, the jurisdiction lies with Delhi High Court. This
My lord, just one submission, if my lord records in the order that the point of maintainability be kept open, my lord.
Come on, you are not filed wakalatnama.
No.
Come on,
I'm pressing
yes,
for
yes,
interim order.
Very well, very well. Grateful.
So, my lord, it will appear on Wednesday under the heading deep,
urgent motion within 5 matters.
and under the same order, leave matter.
Yes.
Grateful, my lord.
The position of
Who is for the 5?
and on the same position. This is item number 5.
Within 5 matters, it will appear.
Right, please, Your Lordship.
Millet, before my lord takes up this matter, Millet,
Lord, I've gone through it as far as the factual matrix is concerned and law is there, my lord. But as far as instructions are concerned from the passport authorities, my lord, because leave was granted by your lordship to move the matter today. Now, my lord, within the four corners of the petition, I cannot find that imperative need that the matter be heard because they have applied for the application is also not forming part of my lord's record nor my brief. The application itself. Now, according to their statement, they have applied for it long back in 2022, if I'm not mistaken. So, my lord, in my respectful submission, my lord, if I get a breather of 1 or 2 days, my lord, I can come with proper instruction. Otherwise, on law, my lord, I'm ready.
Well, very simple issue, my lord. My criminal case is pending. My passport is not being renewed. On earlier occasion, my lord, the jurisdictional court allowed the renewal of my passport. I applied before the passport authority. It was refused, my lord. On that score, my lord, we approached before this honorable court. An order was passed, my lord. That is at page, the last page, 212. Annexure P6.
Page?
212. My lord, passed by the Honorable Justice Shampa Sarkar, that passport has to be renewed for a period of 1 year. But in spite of that, my passport has not been renewed. My lord, 1 year has lapsed. I'm only seeking for a my lord, fresh direction upon the passport authorities to renew the passport.
First, my lord, they should come up. Where is their application for
Where is their
passport?
application?
What they have annexed? Because there is
application for renewal.
My lord, at that time it was a very. My lord, I have a copy if your lordship allows.
Even if that was made a part of the application, lordship, I would not have cut a sorry figure. My lord, the application is not there. My lord knows Mahesh Agarwal's judgment, the guidelines of 2019, which says specific no objection is required, and Mahesh Agarwal also thanks on that. Then if there are more than three,
my
lord, he is not having. This is not the way he should proceed.
Why you persons are the main documents you are not annexed?
My lord allows me a supplementary effort. Are they denying, my lord, that my passport
Not
application is
deny. See,
pending?
what is your case? Simple case, you applied for the passport that has not been renewed in spite of the order obtained from the trial court as well as from this court. So what is the first document is required? Your application.
My lord,
You have to prove in the writ application when you file the writ application, the application before the pass. You have not disclosed that application.
My lord,
and it is not your fault. It is the fault of the all members of the bar here.
January
It is the habit of the total bar. They will file the application by preparing overnight, leaving all the main documents. When the court asks the question, then starting coming with the supplementary
I
affidavit.
apologize, my lord. Kindly allow me a supplementary affidavit.
My lord will kindly allow me to place 2 or 3 paragraphs. Where is the pleading when they have made application? Lordship will kindly come to page 5. Lordship has got page 5. My lord will kindly see paragraph 13. The compliance of the order of the learned court, the petitioner surrendered the passport before the learned court below, which would be evident from order dated 6/3/2020. Now, lordship, this is the paragraph which they are relying on. 14. On 4/4/22, the petitioner preferred an application before the learned judge and the learned court below. They were praying for return of his passport for the purpose of renewal, whereof upon hearing the learned court below, he was pleased to allow the prayer of the petitioner wide order dated so and so, and directed the passport of the petitioner number 1 so and so shall be returned to the petitioner for the purpose of renewal, and further condition of the same shall be returned back to the learned court immediately. Now, lordship, after this, my lord, we kindly see the prayer. Where is the order of the Honorable High Court which has been annexed, even pleaded?
My lord, it has been annexed.
Annexed and pleading is different, my lord. My lord, then I will come to 2025 judgment of the Honorable Supreme Court. That you, in writ petitions, it is not akin to a plaint.
Page 6.
My lord, I come prepared, my lord. They should be better prepared.
My lord, page 6, paragraph 19.
Paragraph 19. Yes.
Then, my lord, what happened after that, lordship? What happened after that, lordship? Will kindly see. After that, what happened?
My lord, paragraph 20.
My lord, can you where are the specific pleadings of these places? My lord, the application is not before my lords. I do not know what they have been asked.
Okay, let they file supplementary affidavit. And London Council for the petition prays for time to file supplementary affidavit. Let supplementary affidavit file by?
My lord, day after tomorrow.
By Friday, after serving the copy to London Council for the passport authority. Let the matter appear on 4th August. And
My lord, same position?
Yeah, same idea. Yes.
I'm grateful.
I'm great.
Lord, by the clock 15 minutes, not more than by the clock 15 minutes, not more than that.
Okay, thank you.
Not more than that, Lord, I have
Not more than 15 minutes?
not more than 15
Okay,
minutes,
thank
Lord. I inquired about what happened earlier.
Yes.
What was the issue, Lord? Why my Lord was, Lord, a
So
little bit of annoyed. Lord, I think there's something wrong somewhere, Lord, done by us also. So I lost waste your Lordship's time very quickly, Lord. I've shown only your Lordship all the provisions. But yesterday, I have given your Lordship one judgment of Supreme Court that is reported in
23.
2023.
Yes.
Just a second. Lord, I was trying to make out a case that we have declared him unfit, and then we declared that the child is adoption. Kindly
Yes.
by this judgment, a new category was added by the Supreme Court. State charge of implementing Juvenile Justice Act shall collect and compile Secretary in the Ministry, Women and Child Development, and Director of CADA on or before.
Yes.
Mentally unsound, children of all such parents may be classified under the category. So, children of a parent, either so among these programs, children, not according to us, we have not proceeded absolutely in terms of what we should have done. I completely bow down to that. But we considered them to be unfit because the child was neglected by them. Who is responsible? The parents have neglected. That was the consideration on which we proceeded. And after this, we got two reports from the government of India. এটা একটা কপি নেবো আছে তোর কাছে এটা দে নিয়ে চলে যাচ্ছিস দাঁড়া আমার ছাড় দাঁড়া দেখ সরা এইটার একটা কপি বার কর এইটার একটা কপি বার কর আছে এখানে এইটার কপিটা বার কর Lord, we received 3 communications from the government of India whereby indicating তাড়াতাড়ি একটু তাড়াতাড়ি দে yes 3 communications from the government of India and CADA guidelines including this unfit parenting category. So, Lord, on the basis of the Supreme, if my Lord takes the 1st December 23 document first, G20 written at the top, right hand side. Lord, got that?
Dated?
1st December 23, this one, Lord. Yes. Lord, kindly take 3I. Accordingly, your state union territory is required to undertake following task to enable Central Adoption Rescue Authority, CARA, to file the report by 10th February. Carry out identification drive. So I want to identify children and child care institute and those not reaching CCI and ensure their registration in Mission Vatsalaya portal by CCI. The children will be classified in 5 categories: orphan, abandoned, surrendered, unfit guardian, children with no visitation. So there was a clear guideline, and then the Supreme Court judgment is quoted at the top, first paragraph. Considering this guideline came, but same is with the Kara guideline that I have handed over. So if for whatever reason authorities decide or declared a parent to be unfit, being unable to take care of the children, then in that case it could be declared. All three documents are saying that. Now, my lord, on this we have declared. Your lordships is to judge, my lord, whether we have rightly done, wrongly done. This is one. Now I'll quickly move into the next aspect. Now today in the writ petition they have challenged, my lord, they have challenged, my lord, the 18th November order. Kindly take the writ petition once. The procedures perhaps has not been completely followed. I completely bow down to that. It should have been followed. They should have been given a hearing. I completely bow down to that. I cannot deny that.
Yes.
So kindly take the prayers once. Prayer A, setting aside 18 November 2024 order by which we declared unfit. And directing the respondents.
Prayer in the writ petition.
Prayer in the writ petition. Page 28. And to restore the custody of the minor.
Yes.
This was the prayer. Lord, yesterday I have given Lord a box, this document to your lordship. এটা তোকে দিয়েছিলাম নাহলে তুই আমারটা থেকে দেখে নে but this box date of process of child namely review
Yes.
আমার থেকে তুই দেখে নে ময়ূক আমি তোকে দিয়ে স্ক্যান করে নে একটু এইটা Lord, very quickly, my lord moves into the, my lord need not look into the first page. This is a reiterated list update. Kindly come to the second page. Lord, take my lord number. Order sheet issued by CWC Kolkata. Everyone's got that? That is the order under challenge.
Yes.
Lord, then what happened? 19th child CWC ends. My role has ended with the passing of this order.
Who passed the order?
The committee, the child welfare committee passed the order, which is under challenge. The role of the child welfare committee ended with that. Thereafter, we had no control over the child.
Correct.
Now it will go to the district magistrate, who will, the Kara will, following the Kara guideline, the adoption will be given. Now, kindly see what happened thereafter. Once, 26 November, child Kara. Yeah. Lord, when I am declaring a child as legally free for adoption, I had no means to know who would be the adoptive parents. It's a completely secret process, completely controlled and conducted by Kara. CWC doesn't even know who are the adoptive parents. Even though your lordships have not masked the names. So I don't know. So from 21st December, the child is with the adoptive parents. 21st December 2024, 1 year, 8 months. Now, my lord, in this sort of a situation, Lord, I'm just making this submission. What would be the effect of an order setting aside the 18 November order? Kindly, for my satisfaction, take section 63 of the Juvenile Justice Act once. And Lord, এতগুলো পয়েন্টস অফ আর্গুমেন্ট হয়ে গেছে না এইখান থেকে যে এই জাজমেন্ট আগে দেখায়নি তো কেউ এই জাজমেন্টটা আগে কেউ দেখায়নি তো যেটা আমি এখন দেখালাম এই 23 Mr. Mukherjee has confirmed nobody has shown this judgment earlier. I don't want to be repetitive. 63, a child in respect of whom an adoption order is issued by 63 of the Juvenile Justice Act.
Yes, special juvenile police unit.
No, effect of adoption, section 63. Lord.
Okay, no.
Maybe my lord has gone to the rules or something like that.
Yes, it's special adoption agencies.
Yeah. Effective adoption.
Yes.
A child should be registered magistrate. No, that is on 21st before 20. That was passed on, my lord, 18th of December. Adoption committee shall become the child of the adoptive parents, and the adoptive parents shall become the parents of the child.
That is not dispute.
Now today,
the problem,
yes,
only the question here, if you are declaring the child and declaring the parents unfit, if that order is not in consonance with
absolutely,
law,
absolutely.
what would be the effect? That is the
Yes,
only
that's
thing.
the only thing. Not I say that
Correct.
if
So if a person is affected by your wrong order, consequence will follow.
not only
If you have taken a wrong decision,
yes, yes,
by affecting the right of
they
one
should not
person,
suffer. They should not suffer. I
Then-
completely bow down. But
then
not
what-
I.
so that's why you give. That's why
I want
I'm
to
asking you what would be the suggestion.
Not that's all. I'm coming to that. Not according to my humble Lord understanding of this, Lord, I will also show you lots of one or two cases. Lord, the child was with them. They are the biological parents. I am not to dispute that. Less than a day. The child is now with the adoptive parents
If you
for almost
decide-
2 years.
If your authority decided in accordance with law, proper taking into evidence, proper giving an opportunity of hearing, yes, the court is 110% with you. Yes, it is the paramount consideration of the child.
Well, let us assume
If the authority has not considered or declared the parents unfit without taking into consideration, giving the opportunity of hearing or considering all the aspects, and declared the biological parents unfit, so what would be effect of that order?
Lord,
That's
the answer I'm trying to
here.
Yes, that's also troubling me. Lord, according to my understanding,
Because you have done the CWC is a constitutional authority.
yes.
If the constitutional authority will do like this,
Lord,
and today only on the basis of the consideration of the paramount consideration of the child taken into consideration, and the court will leave the same thing, again it will be repeated.
Lord,
Again it will be repeated. Because just
Lord,
the day before also I passed one order regarding your CWC.
May I suggest something? Lord, kindly, Lord, do not throw something to me, Lord, kindly, Lord. I am just suggesting something. What I feel that Mr. Mukherjee's client's agony grievance are genuine. I completely bow down. What I find that the adoptive parents had no fault on their part, and especially the child is unfortunate.
But they are also adamant they are not appearing before the court.
No,
Also adamant.
Lord, may I say this?
That court has also recorded.
I was inquiring I called the chairperson yesterday to the GP's office. I was inquiring, do you know she said, I have no means to know.
You not know, but the notice was, that's why they.
Lord, whether they are able to understand the consequence, that I do not know. But today the thing is that they are there, Lord, my Lord, will have to weigh the balance. But for my wrong action, 2 families, 1 child. Kindly weigh the balance. They have been deprived.
Can your fault, love and affection of the biological father can be shut, eyes can be shut down by the court?
Lord, if may I say one word?
You have done some mischief.
When it comes,
or some fault.
Lord, I say let us. Why are you saying this? Lord, let us say there was a wrong. I was looking through the guidelines. We have our High Court has a committee of Juvenile Justice Committee. Justice Shompa Sarkar heading that committee. My Lord may direct an inquiry against the CWC headed by the committee.
Nothing will happen, sir.
No, judge will inquire. So there is no application of any device.
If the court in the res judiction in the judicial side pass an order, what the committee will do? The committee report will prevail, or the judicial order will
Judicial order will prevail. My Lord may direct an inquiry. But what I was beseeching before your Lordship that today, for my wrong action or for an wrong action or an illegal action of the authority, the child who is having a shelter for last 2 years would lose another parent. Kindly weigh this, kindly consider 1 or aspects of this matter. Lord, Mr. Mukherjee's client is saying that I have not proceeded legally. Lord, your lordship has never wanted to see the video. I don't want to prejudice you. But if you ever see it, your lordship will be us. When your lordship is exercising parent jurisdiction, I would beseech your lordship to have a look at it. Because I have seen it. Like a kitten, the child was crying.
What I am telling, something must happen. That's why this
So we have
incident.
compromised the safety of the child.
That's why I'm telling. So that all the thing who could have been decided in the writ petition.
And there are 3 reports.
What you are
Yes,
telling,
yes,
whether
yes,
that is
absolutely.
reflecting in the impugn
No,
order.
no.
Argue that.
Wrongly drafted. Wrongly drafted.
Not drafted, not done.
Yes, not done. Wrongly not
If you
done.
could have been said, yes, all the things are done, but the order not reflected, that is
Those are
different
perhaps
thing.
on record. Those are perhaps on record.
Then
Lord, kindly consider
what you
Mahendra
are
Singh.
telling, yes, video recording, evidence, police report, medical report. If the CWC has passed the order taking into consideration, he will be out.
Lord, kindly considers Mahendra Singh Gill. Much water has flown from then. Perhaps I will be able to show that in
Yes,
the
sir, yes,
records,
that's
those
it.
were,
That's
in the
again
records, those
and
are
again
there.
asking
You
you.
can't improve things.
I am again and again asking you satisfy this court how this order can be
Lord, we
sustained.
should have given them a hearing.
One thing, if you are not able to sustain the order, what would be effect?
Lord,
Because
according
you
to-
have given the child to someone else and the child is with the someone with for the last 1.5 or 2 years.
2 years.
So what would be effect if any
Lord,
order is passed?
that is section 63 will come into play.
Yes.
Their section 63 will come into play. As per law, today the adoptive parents have taken the place of the biological parents. They have the right, Mr.
That what I am telling.
No, let
That's
us
why-
assume for a minute. Let us assume that the order was rightly passed. Let us assume for a minute.
That's I'm telling. What I am telling. If that's I'm telling, you are assuming you will be out.
Yes.
If you satisfied this court, your authority is satisfied that yes, it is in accordance with law. If it is not, what would be the effect?
Lord,
That
today,
is the only.
I would
only
say
thing.
much water has flown today. The things it cannot be reversed. The child's life, child safety, paramount consideration. Your lordship is now the parent patri. You also would have to consider. My lord may admonish me, my lord may punish me, my lord may initiate disciplinary proceeding against me. But the child's future is in your lordship's hand. In one hand, a parent who would not keep the child for a day, and in other hand, one parent. It's not a question of laughing. Please don't laugh.
I'm not laughing.
Please don't
but
laugh.
This is the stand of
Please
the
don't laugh.
CWC. No, please.
Please,
But that's the
please,
thought. I'm not laughing. But if this is the
Yes,
stand of the
yes,
CWC,
continue.
Please don't laugh.
this is the stand of the CWC
Please
that
don't-
parents did not keep in stock.
63.
Yes, 63. No, 63, my lord has seen. Only I'll say show one judgment and conclude. I have nothing more to say. I am not taking anybody's side. I am only concerned about the child.
What side I am? See, you are appearing for the state.
Yes.
That's why the court is telling if this court finds that if the order is not sustainable, what would be the effect of the further consequence? What has happened?
Lord, in my humble submission, considering the wholesome safety of the child, my lord would kindly not direct reversal of the present position which is continuing. My lord would kindly not direct. My lord may keep a vigil. If they fail, my lord may return it to them. But today, review's life is lordship's hand. I am only on that. My lord, take any steps against the CWC chairman. She has categorically WhatsApp me, message me in writing that she is ready to face any consequence, any investigation. So to eradicate the doubt in the mind of the court,
You know how the CVC chairperson has been appointed.
Lord, I have inquired. What have you done in court? Yes, yes.
You know how the chairpersons.
But the judicial, Lord, what she has said, I am portraying. I can't.
That's why really they can say.
Lord, this is reported in 2025 SEC online Supreme Court 1689. One six eight. Take this.
But kindly take paragraph 6 first.
Yes. ये वीडियो बंद है ना? वीडियो बंद है तो बोला नहीं
Madam, I am appearing for the petitioner.
My senior is online.
Yes.
Madam, this is a matter when your lordship, madam, the yesterday only asked my lord the state respondent to my lord take instruction.
Kindly see the page number 2, 7 to 16.
What is your instruction?
My lord, paragraph 7 to 16, my lord.
Say, what is the instruction? I cannot read. What is the instruction? You might have been had a talk with the authority. What is the instruction?
My lord, the instruction that the petitioners being primary teachers are very much bound to the censor.
Okay, I appreciate. See, they are the primary teacher. There was a dispute. The court has allowed to complete the 2 years course. And as per the Supreme Court, the 2 years they have to complete it within 2 years and
Regular course.
once the court is with the petitioner should not interfere. Correct. And that course is regular course. If the career of the person is more important than the scheme of the administration, tell me. Tell me the answer. If you say yes, the scheme of the administration is more important than the career of the person, leaving aside their constitutional right, then I will dismiss here. I record your submission. I will send the matter to the Supreme Court. This is the attitude of the government and advocates of the government, because the personal liberty is nothing. The liberty of the government is prevail. Who has given this instruction? District Social Welfare Officer. Oh, Social Welfare Officer is giving this instruction to you. He has to attend this duty, leaving aside the course, leaving aside the order of the High Court and leaving aside the order of the Supreme Court. If suppose, or you give undertaking, okay, these 2 years they will relax, they will go for that.
Submitted on behalf of the respondent.
Madam, for appearing the respondent number 7 for the authorities, mere taking the written instruction and producing the, but you have to satisfy the authority with regard to the what is law prevailing.
Then, my lord, according to section 4, subsection 2 of Census Act, the state government have the discretionary power to appoint any person.
Correct.
And section
So only these are not the government servant.
Yes.
There are all the regular primary school teachers are there.
Yes,
Their assistant teachers are there. Why you have chosen who is taking the regular course for completing their study? Unfortunate. Kindly come to the paragraph 8. The development neither changes the cadre designation pay. What about the education which they are pursuing the course? Where is the reply to that? Then yes, what is the matter?
My lord, the matter, your lordship, my lord, they were appointed in the year 2025 as
Where is
primary
the
teacher.
appointment order, first order of appointment?
My lord, your lordship, kindly see. My lord, just I am, my lord, giving you the, my lord.
Page 32.
Yes, my lord.
They have been appointed as assistant teacher on probation for 2
Yes,
years.
my lord. Yes, my lord.
Date of joining.
Yes, my lord.
Then
my lord, this is also, my lord, the pursuant to the order of this honorable court, this appointment. Then,
yes,
my lord, your lordship, kindly, my lord.
Page 49 is the order.
then
My
what is
lord,
that?
my lord, pursuant to the order of this, my lord, this page 49, my lord, we joined the, my lord, this 2-year DLED course, regular course, in regular mode.
49.
My lord, yes, my lord.
The order of this court.
Yes, my lord, this court, my lord.
Where is the order? Which portion?
My lord, your lordship, kindly come to, my lord, page 53, my lord, paragraph 9. Malad, may I read, Malad?
Yes, yes.
These relaxation and direction contained herein are issued only for those in-service primary teachers appointed pursuant to the recruitment process initiated in 2009. Whether appointed earlier or pursuant to the latter court direction shall not be treated as precedent for future recruitment cycle. Malad, paragraph 10, Malad. With the following direction, the writ petition such and such stand disposed of, since no affidavit is called for allegation made in the writ petition or Malad, pursuant to this direction, Malad, we Malad joined, even Malad, if your lordship kindly Malad once, Malad, sorry Malad, kindly come to Malad, page 53, paragraph 8. Malad, this was Malad direction, Malad, with the consultation with the highest level of the government official. Malad, the Commissioner of School Education, West Bengal, in consultation with the West Bengal Board of Primary Education and all concerned district primary school councils, has forthwith published on their respective website a consolidated list of eligible untrained teachers along with the recognized institution, including government-sponsored, government-aided and government-recognized self-finance institution offering the DLED course. Admission shall be allowed with preference to availability with the teacher's home district, and if not possible in nearby district, so as to ensure the minimum hardship. The entire admission process, including the relaxation of the academic eligibility condition, must be completed within 12 weeks from the date of communication of this order. Because, my lord, this relaxation, all the relaxation was given because of the peculiar situation. Because I have to be completed this training by 2 years. Otherwise, my lord, I will lose the job. My lord, I have to attend the college regularly. The attendance is the mandatory. And my lord, on the other hand, my lord, if I have to, my lord,
Thereafter, what has happened?
I should, my lord,
After the order
my
of
lord,
the
thereafter I joined and my lord, I'm sorry, my lord. Pardon
after
your
the
lordship.
order, this order was passed when? What is the date of the order? The August 2025. And your order
Yes,
of
my lord.
is
Yes, my
on 6th of March 2025. 6th of March 2025, you have been appointed and you have joined the survey. You have reported your duty. Correct.
Yes, my lord.
Your petitioners are not ready with the
The
case.
respective colleges, my
I
lord,
am
DLED
asking
colleges.
question, after the order of appointment, whether you have joined or not.
Yes, my lord. We have joined in the, yes, my lord, we have joined.
Correct. So after the joining, what has happened?
My lord, after the joining, my lord, we are regularly, my lord, doing the classes.
Correct. Then how the case has occurred? How this how the repetition is? Who has filed the petition?
My lord, the petition, my lord, the in-service teachers who are, my lord, already appointed as in-service teacher and joined the, my lord, DLED course. My lord, they are doing the classes. My lord, your lordship will, my lord, the last impugned order. My lord, your lordship, the last page, your lordship kindly, my lord, consider. This is the, my lord, impugned order. My lord, last page 87. Page 87, your lordship. Once your lordship kindly, my lord, come. My lord, this prompted us to, my lord, file this writ petition.
You are not audible, sir.
My lord, am I audible, your lordship?
Yes.
Lordship, it start at page 80, Lordship.
This is the impugned order they have assigned you.
Lordship.
No, I am asking, in the month of March 2024, you have been, 2025, you have been appointed.
Lordship.
Correct.
Lordship.
You have joined your service.
Lordship.
So where the occasion arises, then you have to join the training for the 12.
Lordship, the impugned order is page 87, Lordship.
87.
Lordship. The BDO issued a notice.
87.
In page 87, Lordship. May I read, Lordship?
Hmm.
In pursuance of the instruction received and the competent authority regarding implementation of Annapurna Yojana.
This is not I am asking.
Lordship.
See, come to the serial. You have been appointed as assistant teacher on 6th of March 2025.
Lordship.
You joined the school.
Lordship.
You are performing your duty. Lordship. So where the order that you have to complete the 2 years course?
Lordship, that order.
Why? When it has come? Once you have been
Lordship,
appointed.
I got a release order, page number 75, Lordship.
Page number 75.
After the admission in the college, I received from the sub inspector of school, page 75. The release order was issued by the sub inspector of school addressing the principal that I have been released from the school on deputation for studying 2 years DLT course on regular mode, Lordship.
Correct.
for the
That's-
session 2025-2027.
Okay.
So from the duty, regular duty, I have been relinquished for doing the course.
That's correct.
Lordship.
Because you are appointed the teacher.
Lordship.
So how you have been released? By which order? The court's order or the administrative order or the
Lordship, page 53. Lordship, page 53. It is my learned senior just now placed it. That I have to complete all the.
That's why I'm asking which portion of the order. This is only for the direction upon the authority to publish the list.
Lordship.
Publish
No,
the
my lord,
weeks.
may I read the my lord entire order, my lord? Then your lordship, my lord,
Complete the 2 years course. Where is that?
Lordship, it is the rules that.
Where is that?
Lordship, rules is not annexed, Lordship. It is a rule that we have to complete the 2-year DLE course after.
That's what you have to show.
51. Kindly page 51 of 51 of 5.
May I place page 51, Lordship? Paragraph 5. Present petitioners, whoever were appointed later in 2025 pursuant to the same recruitment process of 2009, thus missing the window of admission of 2024-2026 DLED session, despite being similarly situated in all material respect to those covered by the aforesaid order. The court has considered and the recruitment process of 2009. Thereafter, selection were delayed for over 14 years due to solely to inaction of the authorities, as the petitioners stand on identical factual and legal footing to those already granted relief and mandatory training qualification arise from.
Yes, kindly come to that 52, paragraph 7.
Lordship.
That's why I'm asking you. Read paragraph 7, page 51, last paragraph.
Lordship, accordingly,
They
this
shall be
court direct
permitted to pursue the higher education.
Madhyamik, there shall be a permitted to pursue completing higher secondary 10+2 equivalent qualification.
Okay.
Open
B1.
schooling.
B1.
B1. Lordship, B1 is the relevant portion.
The petitioners have filed the present date application challenging the orders issued by the block development officer instructing the petitioners assign the work of polling station. Where is the order?
Lordship, the order is at page 87, Lordship.
That is only a one order.
Lordship, that is order of only 1 or 2 petitioners. Every individual petitioners have received from their respective blocks, Lordship. Subsequently, Lordship, yesterday my learned senior has placed on order, Lordship, regarding the census duty, Lordship. I have prepared one supplementary affidavit also.
Assign the work for collection, verification and field level validation of family data under the Annapurna Yojana scheme. Full stop. The main contentions raised by the petitioners in the present application that the petitioners were appointed as an assistant teacher on 6th of March 2025. And after the appointment, the petitioners have reported their duty. Subsequently, there are several litigations with regard to the post of assistant teacher before this court in several subsequently several litigations have been filed before this court with regard to the post of assistant teacher. When the matter being WPA number 13989 of 2025 and WPA 13966 of 2025 was taken up for hearing by this court, this court directed that the teachers with only Madhyamik qualification, semicolon number 1, they shall be permitted to pursue and complete higher secondary within bracket 10+2 or equivalent bracket close qualification through recognized open schooling or other approved modes while continuing in service. II. Upon enrollment and as per eligibility under NCTE regulation within bracket with necessary relaxation hereby granted as a special case bracket close, the petitioners shall be admitted to and complete the 2-year diploma in elementary education within bracket DEI full stop ED bracket close
EL.
DLED, yes. But here it recorded something else.
DELED.
EA.
EL.
L, that's why.
It is small L.
That's why. DELED. E small hoga. Course through any government sponsored, government aided or the government recognized self-financed institution, comma, in regular or open oblique distance learning within bracket ODL model without any service interruption. Service instruction. In terms of the full stop, the petitioners were the graduate. The petitioners were not having the delete course. Accordingly, the petitioners have applied before the authority to allow the petitioners to go for the delete 2 years course. Accordingly, the respondent authorities, where is the release order?
Page 75 is one of the order. The petitioner number 1.
The respondent authorities.
Subsequently, there are orders.
The respondent authorities have released the petitioners from school on deputation for studying 2 years DLID course on regular mode for the session 25-27 in service primary teachers. After the release of the petitioner from their respective schools, comma, the petitioners have joined their colleges. Their respective colleges to complete their diploma course. And now they are pursuing their diploma course on as regular student, and the said course is for 2 years, and the 2 years will be completed in the year 2028 only.
27. 25-27 is the session.
But you have been released 26.
Lordship, the session is 25-27.
Okay, will be completed in the year 2027. 2027. Full stop. As the petitioners have been released from the respective schools and are pursuing their regular study for completing the diploma course in terms of the order passed by this court. In the meantime, comma, the respondent or the block development officer have issued the impugn order by assigning the work for collection, comma, verification and field level validation of the family data under the Annapurna Yojana. Learned counsel for the petitioner submit that the work assigned to the petitioner is the work assigned to the petitioner, comma, the petitioners have to go to the field work and to collection the data. If the petitioners will go to the field work, then the petitioners will not be in a position to attend their regular classes. In the meantime, the petitioner will also apprehending that there will be an examination. The petitioner will not be in a position to appear the examination.
May I have a supplementary affidavit? Yesterday, my learned senior shows one notification. I have come with a supplementary affidavit. I have given to them also. That's census duty, Lordship.
What?
The census duty, after filing of the petition, I was entrusted page number 6 of the supplementary affidavit, Lordship. Yesterday, my learned senior shows before your Lordship.
तुम लोग रखते कहाँ यार? Supplementary affidavit कहाँ है? ये तो उनका है supplementary. It is your supplementary.
Lordship, just
what they have given yesterday. This is the census duty.
Census duty, Lordship. That is in the
Learned counsel for the petition submit that during the pendency of the writ application, now the respondent authorities on 25th of July 2026 have issued a notice directing the petitioners for 3 days training program with 100 numbers field enumerated ICW. Yeah, Census 2027, and which is scheduled in SGSY Hall -1 and 2, Swarnanagar Development Block on 27/7 and 29th of July 2026. He submits that in terms of the said notice, if the petitioners will have the petitioners have to report their duty and they have to attend this training, and if the petitioner will if the petitioner will appear in this training, then there will be a shortage of attendance in their regular diploma course, which is for 2 years. Full stop. London Council for the petitioner prays for setting aside the impugn order wherein the duty has been assigned for the completion of the Annapurna Yojana as well as the training program of the census 2027, the क्या बोला? As well as of the census 2027. Fully. The responding authorities have filed the report wherein it is mentioned that the responding authorities have issued the impugn order for implementation of the government policy by issuing administrative instruction regarding distribution, collection, verification, and digitization of the family level data collection forms. Full stop. She further submits that the role assigned to the booth level officers is purely administrative and field oriented, considering the BLO already possess both booth-wise familiarities with house, hold stand, electoral geography, thereby ensuring speedy, transparent and efficient implementation of the welfare of the program. The orders have been issued. Full stop. London Council appearing for the state further submit that the deployment of the petitioners will neither change the cadre, designation, pay, service condition or seniority of any employee of the petitioners. London Council for the state submit that the authorities have issued the said orders for the administrative reason, and the petitioner have to comply with the direction issued by the authorities. At the London Council for the respective parties peruse the materials on record. Admittedly, the petitioners were appointed as the assistant teacher and they have reported the duty. But subsequently, it is found that for the purpose of continuing the post of assistant teacher, the petitioners should possess 2 years diploma course, that is DLED. DLED. This court by an order dated 14th of August 2025 permitted the petitioners to complete their higher secondary to complete their diploma course, and accordingly the authorities have released the petitioners from their respective schools to complete their diploma course. Now they are pursuing the diploma course, 2 years diploma course. And this said diploma course is a regular course, and if the petitioners will allow to go for the work assigned by the respondent authorities, that is for the implementation of the Annapurna Yojana and the training of census 2027, the petitioners will not be in a position to attend their regular class, and they will also miss their examination. And it is the mandatory for the petitioners to complete their diploma course within 2 years. And if the petitioners will not be able to complete their diploma course within 2 years, there will be difficulty in their service as assistant teacher. Full stop. The respondent authorities failed to consider that the petitioners are pursuing their diploma course in terms of as per the leave granted by this court, and the authorities have also released the petitioners from the post of assistant teacher to complete their diploma course for 2 years. 2 years. Considering the above, this court find that by issuing the impugn order, by assigning the work to the petitioner for implementation of the Annapurna Yojana and for attending the election training for election census for 2027 is bad is क्या बोला Annapurna Yojana for training of the census 2027 is not in accordance with law. It's not in accordance with law and has not been passed, has not been issued, has been issued without considering the leave granted by this court and the release order passed by the authorities for completion of the diploma course. Accordingly, the impugn orders assigning the duty of implementation of the Annapurna Yojana as well as the training for the census 2027 are set aside and closed.
Grateful, my lord. I'm grateful, my lord.
उससे ऊपर रहेगा ना will not counsel for the state further submit that as per section 4
subsection 2 and
Section-
section 4 subsection 4 the state government have discretionary power appoint and
Replace.
delegate
where you mention that is not in the report.
Subsection. That is my verbal submission my lord.
Subsection 4 of where is the law? Section कौन बोलना?
Sir, I have soft copy my lord. Section 4 subsection 2 of the Census Act 1940.
Census Act subsection 4 of section 4 of section 4 of the Census Act section 2
Section 4 subsection 2 and section 4 subsection 4 of the Census Act 1948.
subsection 2 and subsection 4 of section 4 of the Census Act, it is the duty of the petitioner to go for the training and accordingly respondents have assigned the work for had directed the petitioner to attend the training of
Grateful, my lord.
Grateful.
Item number 181.
Grateful.
For the petitioner. That pursuant to your lordship's order dated 25th June, if your lordship may kindly consider, my lord, we have received a report from the NKDA, and my lord, this is our exception.
My lord, as regards the NKDA is concerned, I have consulted the NKDA authority. They also don't want to make it an adversarial litigation. What is bothering us is that, my lord, we had given an advertisement. That advertisement, the last date for filing of the
Advertisement of?
For town vending committee, for reconstitution of town vending committee. Because there was a town vending committee, some members from there had resigned, and that is why we want to, as per statute, you have to form a town vending committee first. So that town vending committee, the last date for the advertisement was means for filing of applications was 21st, my lord. Now on 21st, we had received some applications, but to be very candid before the court, honorable court, the town vending committee, hawkers union of the town vending committee, we did not find it from within the notified area. And on 22nd, we found some applications which were from the from other persons, including the petitioners union. That was on 22nd. Now, if that application, if we have to make an application again, if your lordship is not satisfied that these persons, although most of their residences are within the NKDA area, but they are registered with a union that is whose registered office is outside the NKDA area. If your lordship is not satisfied to that effect, my lord, kindly direct me so that we can float another advertisement and
so now what is the subject matter here?
My lord, the subject matter is, my lord, a notice was issued by the NKDA, my lord, thereby, my lord, calling upon the hawkers to evict their places. My lord, we challenge that, my lord, that your lordship state that, and in view of the Street Vendors Act, your lordship, what failed from your lordship, that the NKDA should, my lord, implement the act.
Correct.
And the first process was, my lord, constitution of the town vending committee. My lord, there is a very positive effort taken by the NDA. They have constituted the town vending committee. But, my lord, our limited grievance is that, my lord, they have inducted representatives of the vendors from an organization which is not within the NKDA area. My lord, the last date, so far as the advertisement was concerned, was 21st of June, and we submitted application on 22nd. And as it appears from the report, other organizations from NKDA area, they also submitted their application on 22nd. My lord, my prayer is, my lord, let the town vending committee be reconstituted with vendors representatives from the NKDA area, which my learned senior is also, my lord, addressing the court. If the, my lord, this provisional town vending committee is constituted, then, my lord, they will conduct the survey. They will identify the hawkers.
So how
They
this notice has been issued?
My lord, this notice was issued, my lord, in 3 newspapers.
Leading
So
newspapers.
if there
my
is no
lord.
committee,
There was previously, my lord, there was a committee. Some members, my lord, resigned.
so first the committee has to be regularized.
Yes.
That committee.
So how soon you will do?
My lord, kindly grant us the,
So see, this order, this court passed an order with regard to the eviction of the petitioner.
No, we are not on the eviction
Correct,
now.
correct. So you wanted, you do your work with regard to the regularization of your committee. Once your committee is regularized, then you
My
take.
lord, may I make one prayer? Possibly my learned friend will also agree to, I make a prayer before your lordship, my lord, because Newtown is a very beautiful area and the hawkers also cannot be
Still.
removed.
Still.
And then the hawkers cannot also be removed in a inhuman manner, but they have to move from the place where the vending is being continued if that is not if that is not a proper place. So we
So I will dispose of this.
no, my lord, kindly do not dispose of. My lord, your lordship's intervention is required, my lord.
If
And
in
kindly
all
do-
matter the lordship intervention will require, then
It is for this at least probably because this matter is, my lord,
lord,
is a bit different,
It
my
is
lord.
my prayer too, my lord. I second my.
So what is the prayer now?
My lord, my prayer
That
is.
I will allow you to constitute your committee in accordance with law and file the report. Then we'll see to that. Till that period, you know, not to
No,
take.
eviction, we are not going on by the eviction.
So why the repetition should kept pending?
Because, my lord, there are many formalities because there will be many formalities. There may be some other
So
problems.
now what order you want from here now?
My lord, let me be given a direction. Let the NKD authority be given a direction, my lord, to file and to float another advertisement because all the persons, all the unions, they are not falling within. No, they are within the means. Their registered officers are not within the area, within the notified area. Acted object.
My lord, this is the statute, my lord. Section.
That it is constituted, they will file. They will have a first meeting, and thereafter they will conduct a survey. My lord, I believe, my lord, your lordship's intervention is required at every stage, so that the entire episode can be dealt with
So survey of the state has completed.
No, man.
Town vending committee has
Not completed. 4 not completed. Now first you have to
My lord,
commit.
22 needs to be, my lord, complied with first. 22.
There is ambiguity in Rule 22. That was also bothering me because it does not say anywhere that we have to induct unions whose registered
vending committee.
offices are within.
So when you have issued the notice for for the constitution of the committee,
we had given 7 days notice, my lord.
My lord, this was, my lord.
earlier when you issued the notice.
My lord, kindly bear with me. 3 newspapers.
11 July.
Page 16, my lord, 14th of July.
No, their report that kindly come to the report and page 14. Page 14.
Page 14, it's in Hindi.
That is
My lord,
after
the
the
advertisement at the bottom, my lord, the date is 10th of July.
10 July.
11 July. Top. 11 July public, but that is after the order passed by
11
this
July,
court.
yes, my lord, 11 July is the newspaper's date. My lord, lordship kindly finds the notice at bottom.
They have signed the notice on
Yes,
it.
that notice is dated, my lord, 10th July.
Then
My lord, we submitted our application on 22nd and we find that other, my lord, organizations from the Newtown area, they submitted on 22nd itself. My lord, my prayer is, my lord, let them consider all the applications submitted by all the unions and let them constitute the town vending committee as per 22.
My lord, as per my humble understanding is 22 is rule 22. There
Why?
is
What is the ambiguity? The appropriate government may by a rules made on behalf of provide them for the term and the manner constituted.
No, not section 22. Ashwin.
Section 22.
Rule what rule ছিল ওটা? Rule 4 is, my lord, there is ambiguity, but if we পড়ো না কেন সময় মতো ভালো লাগে না।
Rule 4 of this is Delhi state vendor.
রুলটা কোথায়? রুল 4টা কোথায়?
The rule 4 is, my lord, an exact replica of the act itself.
স্যারের নাম দিস কিন্তু NKDF Section 22 and Rule 4, my lord.
Similar as it is the act.
Yes.
As it is the act.
Act.
So I will allow you in
My
terms
lord.
of the publication, whatever the application, you complete the process for constituted of committee. And after constitution of committee, you submit the report. Till that period, no eviction.
Now, my lord, what is bothering me, my lord, is whether if your lordship kindly passes a dictum, my lord, whether we can induct, because applications are coming from vendors whose offices are registered even outside the authority, NKD authority area, notified area. So if we can induct them also, and obviously, my lord, who come within the ambit, whose registered offices come within the ambit of NKTA, they have nothing can be said in this regard about them. But as regards there is some ambiguity. That is what is bothering me.
If considers necessary, provide the constitution more than one town vending committee or a town vending committee for each zone or the ward of. So why you going for the outside? It is the new town. If the members who are applying, there should be a of the new town only. Why the outside?
Well, kindly let it fall from your lordship.
That is not the subject.
That is the object of the act. Because, my lord,
if you come, then they will raise objection, then the court will decide.
Because they have raised an objection. They have raised an objection.
There's an objection, you decide. The competent authority decide. Why this court at this stage take the burden of the authority?
Because after the, my lord, after the town vending committee is formed, then thereafter only we can take all the.
That's what I propose. You do in terms of the publication made by you. If you want, I will extend, or you can further make a publication. Further make a publication when any day and time is prescribed for publication.
Time was prescribed 21st.
No.
7
How many days? 7 days notice.
7
days notice. You publish a further notice.
Further notice for 14 days we
14
can
days,
do.
and you complete this. And if there is any reason, first before constituted a committee, if any objection, that objection be decided by the appropriate authority. And if anybody is agreed, then they come with this court with whatever the application or proceeding, whatever it.
My lord, I bow down. My lord, may I make a humble prayer before your lordship, my lord, because we after we form a draft reconstitute town vending committee, my lord, we can give everybody, every stakeholder, an opportunity of hearing.
Yeah, that's what I'm telling. See, suppose you are publishing a notice on Monday.
My lord.
Correct.
My
So
lord.
7 days notice.
My lord.
If Monday, if you go by Monday, then it is a 27. It is on 3rd of August.
My
so
lord.
7 day it will come to the 11th.
My lord.
Correct. So from 11th onwards, with whatever the notice has come, then you have to scrutinize. If any report, if any objection has come, you have to decide that.
My
Within
lord.
15 days, you have to decide. If they decide, if anybody is agreed with that, they will challenge that. If they not challenge, then you complete the proceedings, constitution of the committee. If there is an objection, first you have to, your authority has to decide. You cannot say, no, this is objection, we cannot go for. Your authority decide whether the outsider is be inducted or not to be inducted.
My lord.
Then if it will come to the court, then the court will decide. that.
After we constitute a draft committee, my lord, your lordship
Yes.
kindly let it from your lordship.
Yeah, then,
that after
then
it is,
if there is no objection and if you constitute a committee, then you file a supplementary affidavit.
My lord.
According, the court will pass appropriate order, no problem.
my lord. Deeply obliged, my lord.
The NKDA has filed the report and submit that in terms of the act and the rules, the NKDA has published a notice for constitution of the committee. Now the NKDA submit that the NKDA intends to publish a fresh notice for inviting the application to be a member of the committee. Accordingly, the NKDA is given liberty to publish a fresh notice calling an application for membership of the committee within 1 week from date. And
Well,
after,
kindly, if your lordship makes it at least 10 days from
within
the
2 weeks, within 2 weeks from date.
Grateful, my lord.
And after receipt of the applications with regard to the constitution of the committee, the concerned authority will pass appropriate order with regard to the constitution committee. And if any objection is raised by any of the applicant, the same shall before constitution of the committee, the objection shall be decided by the competent authority. And full stop. Let the report be filed by the NKDA before this court within a period of 4 weeks from date.
My lord.
Let the matter appear on 3rd September 2026.
My lord, kindly let the
Interim order is extended till the next date of.
My lord, kindly let a time be fixed as like today, my
or
lord.
under September का date
Any
है?
time as per your lordship's convenience.
बोलो कब है? 3rd September 12 noon. Great.
Deeply obliged, my lord.
उसमें ऊपर आएगा report filed by the NKD and exception filed by the petitioner, the copy the record. Take your book back.
Deeply obliged, my lord.
Next.
This is a matter relating to the holding of the Sabuni Mela. The petitioner sought for the permission from the competent authority, executive engineer, National Highway Division. So land belong to the National Highway Division.
Yes, what
and
is
lastly,
the
2 decades, they are the holding the
terms of last direction passed yesterday. We have got the instruction, executive engineer, and the police authority and the BDO, 3 reports I have received. The executive reports engineer report is important here, if the permission has been sought for.
Have you saw the copy? Yes, there's allegation.
There was an allegation regarding the financial irregularities that have been stated. It is the last 2 decades they are holding the.
That's correct. You are the, who are you?
I am the secretary of the committee.
Where is the,
It has
Not
been,
before your lordship.
this is the annex the copy on Cooperative Society Act. It has been registered. Kindly come to page 13.
Where is the authorization?
Page 13 and 14, the
secretary.
Secretary holding the the
No power.
authority.
But where is that? Where, kindly come to the cost title.
Cost title, they were representing.
Cannot mention.
Nothing.
In the affidavit portion, they have been mentioned as the
Kindly come to the paragraph 1.
Paragraph 1.
Unwilling discharge. It is not that you are the secretary and you've been authorized under the act to represent, or there is no even there is no resolution authorizing you to file this writ application. How?
Only they have stated in his affidavit, they have been.
No, that is different thing. But your contention, I am the secretary, but in the cost title in paragraph 1, there is no description. Even there is no resolution.
Kindly appreciate the paragraph 4. They have been stated the Panchkura Bajar Chourangi More Puja Committee. Samiti is performing Durga Puja Sabuni Mela in every year.
That is
correct.
Land of the National Highway Authority.
That's correct. But first you have to establish your. First, you have to establish then you have to give the number of the vendors to whom you will going to allot, then I will pass an order.
They have been.
Because there is a serious allegation against you. With regard to the monetary transaction and all these things. If you give the number, I will tell the police to verify and then I will allow that.
They have to take a decision of before the competent authority. They allow them all the vendors to have to.
If the court will allow, that's why if the court will allow, automatically they will also give the number, because there is an allegation you are allotting the space for the monetary transactions. Correct. You are the committee. You are allotting the space by taking the money. So this is the allegation. How you are allotting? There is any
there is of course they have some procedure over there. They have not disclosed in the repetition.
And some of the person made a complaint and RTI have also been
RTI. I have not annexed the RTI. I have.
So
they have to should have disclosed about the what is the holding that, but they have not stated. They have been only asking for the simply they are holding the area. They have
do one thing. I passing on order. Today evening you give the names of the vendors to whom you are going to be allowed. If you give, then I will direct the police authority to verify the genuinity of the name and come tomorrow with the report. Then I will pass on.
But subject to correction, my lord. If your lordship allows me, my lord, there are RTI, my lord, which, my lord, clearly indicated there are some sort of malpractice and financial irregularities.
That's why.
And, my lord, in a similar portion of a property, one writ petition was filed. The Honorable Division Bench of this High Court, my lord, has intervened and directed the National Highway Authority of India, my lord, to clear the encroachment, my lord.
This is a 15 days.
That is a public interest.
That is a 15 days. That's an encroachment.
Why I submit this? Because, my lord, this is also this RTI. May I hand up? The last point will be important, although, my lord, kindly ignore the language, my lord, the way it has been drafted.
No, this correct. But it is that's why they are asking the permission for the 15 days. It is not the encroachment. They are asking the permission, and they are you have allowed for the last several years. Not the only allegation with regard to some money transactions.
Yes, this is the first time after 15 years this kind of voice have come up.
That's why to save your skin also, to save from allegation from the villagers. So if he will give to today evening by 5 PM, he will give the name of the vendors to whom they are going to allot. Then you, police authority, will inquire from the local persons only. They are the locally only. They are not the outsiders. So police persons will inquire by tomorrow and by tomorrow, but and come tomorrow at 2 p.m. with the report, it is correct. If they say now they have obtained money and all these things, then I will.
My Lord, directs will do that, but just
Because
only
you
the-
will
it is
be,
my duty
the
to point
authority
out.
will also save this code. Then
Yes, yes.
the Mela can also
Absolutely,
consider.
because this is my duty to point out, my Lord. Another thing, my Lord may kindly record the points I have taken so far. The
But I
locus is
will
concerned.
record
Yes.
this. I will record this, and that's why I will record this, and I will give the liberty
Yes.
to the petitioner to whom you wanted to allot the space for this period of Mela. Give the total name, number, and the contact details to the police or the local police.
My Lord, that we have followed completely. My Lord, the locus of the writ petitioner, even the grounds, my Lord, it is of public
That is
cause.
another. What is that?
Public, it's not an adversarial litigation and cannot come into the.
Resolution they have- Well,
Kindly see the grounds, my Lord.
capacity of the secretary they have filed.
My Lord,
But where is that?
kindly see the grounds at page 8, my Lord. Kindly see the grounds. My Lord, grounds 2, my Lord, Shravani Mela festival is going on since 25 years and the club is a registered club registered by West Bengal Societies Act. For that cannot 3 video of the concerned block issued certificate for Shravani Mela holding.
That's what I am not going into that.
That's what, my Lord, it's more of a public cause. My Lord, the adversarial litigation cannot lie, my Lord. Why
Not adversarial. See, it is, and that's why this is not the adversarial litigation. It is the committee. Committee have. If suppose you are the political party or non-political party, you wanted to go for the dharna, it will go to the division bench, the adversarial party. It has to come to the court only if the permission is not granted. It is not that it is the public only.
It's largely for the public cause. That's the only thing for that.
Yes.
Yes, come back with the details of the particulars.
And you file the supplementary
Yes,
affidavit
yes.
giving the details.
Along with the authorization or regular.
The petitioner has filed the present date application praying for a direction upon the respondent number 6 and 7 to give permission to the petitioner for holding Saravani Mela Festival 2026 from 31st of July 2026 to 14th of August 2026. The learned counsel for the respondents raised preliminary objection with regard to maintainability of the present writ application on the ground that the petitioner has not mentioned either in the cause title or in the body of the writ petition whether the petitioner has been authorized by the committee to file the present writ application. The learned counsel for the respondent has also filed the filed report in terms of the order passed by this court dated 28th of July 2026, wherein the executive engineer National Highway Division -2 has raised objection for grant of no objection certificate to the petitioner for conducting the Mela from 31st of July 2026 to 18th of August 2026 on the ground that the authorities have received several complaints that the petitioner has unauthorizedly collected money for allotment of the stalls during the Mela. It is further mentioned that some of the persons have made an RTI before the authority with regard to issuance of the no objection certificate. They have also raised objection with regard that in spite of the order passed by the Honorable High Court Division Bench of the High Court, how the permission has been granted. Full stop. This court finds that as regard the order passed by the Honorable Division Bench, that is with regard to the illegal encroacher upon the government land. Here, in the present case, the petitioners only asking the permission for the 15 days to conduct the Mela from 31st of July 2026 to 14th of August 2026. And as such, it cannot be said that the petitioner are the encroacher of the property in question. As regard the allegation made in the report of the executive engineer, the petitioner is directed to provide the list of the intending persons whose name the stall places have been allotted by the petitioner for installing the stall during this Mela to the Officer in charge or inspector in charge?
Officer in charge, Panchkula Police Station.
To the officer
Respondent number 10, my lord.
to the respondent number 10 by 5 p.m. today, and the on receipt of the details of the intending persons in whose name the places have been allotted for installing the stalls, comma, the respondent number 10 shall inquire the genuinity of the list, if any, provided by the petitioner to the respondent number 10 and to file the report before this court by tomorrow at 2 p.m. Let the matter appear tomorrow at full stop. As regard the objection, as regard the maintainability of the objection raised by the respondent, comma, the petitioner submitted. The petitioner is the secretary of the what is this? Secretary of
the, my lord, the
association.
Panchkula Bajar Chourangi More Puja Samiti.
Of the Samiti,
Puja committee, my lord.
Samiti, and as per the act, the secretary is entitled to file the writ application. But the petitioner prays for time to file supplementary affidavit by disclosing the document that the secretary has been authorized by the committee to file the present writ application by tomorrow.
May I just one indulgence, my lord, lordship kindly direct the respondent number 10 to ensure while making this inquiry that no financial transaction should take place.
Respondent shall inquire into the same whether any financial transaction has been made for allotment of the places for installation of this.
My lord, respondent number 10 instead of respondent number 9 is the my lord, inspector in charge. 10 is the fire service.
10
is the fire service. Respondent number 9, inspector.
9.
Respondent number 9.
Inspector in charge. Respondent number 9. Let the matter appear tomorrow at 2 p.m. Next.
Lordship, I appear for the petitioner. This is also a matter under the Assisted Reproductive Technology Act, Lordship. The mother is within age. The facts are different, that they had lost a child at around the age of 18, Lordship. So the mother is 43 years and the father is 57 years now. Lordship, this is the affidavit of service on record. Lordship has passed an order yesterday also in the similar manner.
Where is the report?
Lordship, yes, I will hand over the report.
You are appearing for?
Yes.
I'm appearing for the Union of India, Lordship.
Lordship, this is the
what is the
certification? Fitness.
Lordship, this is appearing for the first time, Lordship. I need to get the report in this, Lordship.
What report?
Lordship, they must.
State has nothing to do.
The Union, Lordship, kindly give an.
Lordship will kindly not keep it pending. Lordship has
State is nothing to do. It is only with regard to the act. The court has to see whether any of the either both the couple or any of the couple is coming under the purview of the act, and this medical.
Lordship, they one of the father is beyond the purview of the upper age limit, that is 57 years. Lordship, I need to get an instruction on this, Lordship.
Consider the judgment passed by this court as well as several orders passed by this court as well as the judgment passed by the Justice Sita and Justice Bhattacharya.
Lordship,
and the division bench of the Kerala High Court.
Lordship.
Wants to consider and Lordship is granting me liberty. I will hand over.
You do one thing, give the judgments, copy,
now.
Come tomorrow.
Lordship, tomorrow, Lordship, if some precedence may be granted, Lordship, I
take the judgment,
Lordship,
read,
I have
it with the authority,
Lordship.
inform the authority, this is a situation.
Lordship, I will come.
Lordship. Then counsel for the petition has filed affidavit of service and the medical fitness certificate of the petition number 1. Let the same be kept with the record. Then counsel for the respondents prays for time to take instruction accordingly for the interest of justice case adjourned. Let the matter appear tomorrow under the same heading within 5 matters.
I'm extremely obliged.
Next.
Obliged.
In my lord, I beg to appear for the respondent Gram Panchayat, my lord.
My lord, I am for the petitioner, my lord. This petitioner was granted Gramin LPG distributorship license in the year 2019.
Gramin LPG
distributor cylinders, my lord.
Yes.
To the customers, my lord. My lord, the petitioner was selected. Thereafter, as per the guidelines of the respondent authority, petitioner, my lord, built up the godowns and other, my lord, infrastructures, my lord. Respondent authority became satisfied. Then
granted approval, then issued appointment letter. That is the page number, my lord, 47, my lord. Now, my lord, what happens, my lord?
Yes. First to tell the story. Then,
my lord,
after the allotment, what has happened?
my lord, then, my lord, with the no objection from the Gram Panchayat. Gram Panchayat issued, my lord, series of letters, my lord, stating that they have no objection, stating that there is no school, college, buildings, my lord, religious, my lord, institutions, my lord, no, nothing was there, my lord. My lord, due to, my lord, some financial crisis and, my lord, the COVID-19, my lord, the petitioner could not run the, my lord, start the business, my lord. In the meantime, my lord, the renewal period, my lord, has come, my lord. Appointment for license was for given 10 years. But within 3 years, my lord, the renewal and safety organization, my lord, the respondent, my lord. The petitioner, my lord, approached the Gram Panchayat again and again, giving NOC. Because of the gas cylinder rules, my lord, the NOC from the local body is required. My lord, I applied. No response. Then approached to the block development officer. Block development officer, my lord, directed the Gram Panchayat to issue NOC. No result. Thereafter, again, my lord, approached to the subdivisional officers. Birbhum, my lord. Subdivision categorically directed the Gram Panchayat to issue NOC, my lord. But my due to non-renewal, my lord, I could not, my lord, start the, my lord, the business, my lord. My lord, kindly come at page number, my lord.
What is the prayer?
My lord, prayer, my lord, 2 prayers, my lord. Series of NOC has been given.
Consideration by the Panchayat. Panchayat.
My lord, 2 prayers, my lord. One is consideration by the Panchayat. Another is, my lord, series of NOC has been given by the Panchayat. As per the, with the NOC from the Gram Panchayat, my lord, I constructed. And the Panchayat in the year 2025, my lord, issued trade license, granting in my favor to run the business till 2027, my lord. My lord, this is, my lord, also, my lord, here, my lord. So, my lord, without, my lord, NOC, my lord, my renewal may be, my lord.
So your 2 prayer is first is consideration of by the Gram Panchayat for issuance on NOC. Until the NOC is issued, we are having the 10 years limited period. So you may be allowed to continue pending the NOC from the Panchayat. This is your case.
My lord.
Yes, who is Panchayat?
I am for the Panchayat.
Yes, what is the reason?
My lord, first, my lord, on instruction, my submission may be
Naturally,
taken.
instruction only.
That, my lord, the Gram Panchayat, in principle, my lord, have no objection in the petitioner setting up his LPG license within the Gram Panchayat. But, my lord, the reservation is somewhere else. The reservation pertains to the fact, my lord, that in granting a license, my lord, we, under the rules, is bound to check whether the safety and security of that place has to be ensured. In that regard, my lord, my instruction is that, my lord, that within 30 meters of the place where he intends to set up the LPG godown, my lord, there are not 1 but 2 educational institutions, my lord. One is a college and another is a school, minors, my lord. So we don't want to endanger, my lord, the lives of, in something happens. It's not a small, it's a big godown, number 1. And number 2, my lord, the Panchayat has also informed me, my lord, to place it before your lordships, my lord, that with regard to the plan of the building in which they want to do, the Panchayat authority does not have any record relating to the plan of the godown also. These are 2 grounds primarily, my lord, on which the Panchayat is averse, my lord, to grant him license.
Still you have not started.
No, he's not started yet, my lord. So Panchayat is averse, my lord, in granting license at the location in which he is intending to establish his godown, my lord. That's one part of the one limb of the submission, my lord. The other limb of the submission that would be, my lord, that my learned senior has relied on certain documents which he claims to have been issued by the Panchayat, my lord. My lord, it is my specific submission, my lord, and if your lordship wants, my lord, I can put it on affidavit, my lord, that the document that he have annexed neither are in the record of the Gram Panchayat, nor there is any official memo number given to those documents, my lord. So the veracity of those documents, my lord, we cannot take responsibility at this stage, my lord, and we are ready, my lord, to file an affidavit to that effect, my lord. And our, my lord, the present dispensation, my lord, of the Panchayat, my lord, they have inspected it, and the other, the documents in support of my learned senior friends, clients, contention before your lordship that the Gram Panchayat has issued, my lord, those records shows, my lord, it has been written there that there are no educational institution. But, my lord, my specific submission instruction is that, my lord, within 30 meters there are 2 educational institutions, my lord. One is a school and the college, my lord. On this ground, my lord, and it's not that we have sat tight over the matter, my lord. We have informed the block development officer of our incapacity, my lord, in that sense, my lord, and also given a copy to my learned senior friend's client, my lord, which he has been pleased to annex for your lordship's consideration, my lord. So, my lord, it is absolutely incorrect to say, my lord, that we have sat tight over the matter. My lord. Those are my respectful submissions.
Just not granted, he will not allow.
No, we cannot supply because till the time all the required licenses are in place, because peso license is also got expired. Because his one of the relief which he has sought for is also against the peso authorities. So peso license has already expired. So there is no renewal of the peso license. As what I understood is the peso in its approval has said that these certain there are no objection from the local body is required.
Well, everything
and-
hinges on me, my lord. I give, so peso gives.
Yes.
Because if you look at page 79 of the writ petition, if your Gram Panchayat stand is clear at page 79.
Yes, my lord. That was I was placing, my lord. That we have made our stand very clear, my lord. With a copy
We
to
don't
the-
have any objection. If the licenses are all in place, we will supply.
Well, we are also, in principle, my lord, we want this LPG godown to be established in our village, between it will inure to the benefit of me also, my lord, as a pradhan who resides in that village, my lord. So, my lord,
Yes,
in
if it
principle,
is
I'm
a
not
school
against
and
it.
college, how
My
it
lord,
can
my lord,
be?
that is not my lord the correct, my lord. My lord,
If it is not correct, then I will
Yes.
appoint a
my
special
lord,
officer.
yes, yes.
You identify the place.
Yes, my lord. But
At the cost
because
that
of the
lordship will
district
impose the
magistrate
cost.
sir, granted
Yes.
license, BDO, my lord, inquired into the fact, has my lord directed the
No
pradhan.
problem. If it is so, you are denying with regard to the
My
allegation.
special
made
officer
by
may be
the-
my lord.
So I will appoint a special officer.
My lord, my lord.
and a
That will
special
be my
of-
lord.
yeah. First you have to satisfy which is the land. Where is the land?
My lord,
He has given the
Have you
description.
given the map?
yes, yes,
Plan.
my lord,
He
it is
has-
the schedule
he has
is stated,
given-
my lord, page
given the
number, my lord.
Page 63.
Yes,
Where
my
is
lord.
the
Yes, my
LOA?
lord. Yes, my lord.
Where is the LOA? 47. Where is the survey number? Plot number?
My lord, kindly
My
have
lord,
page 38.
Page number, my lord, 34, my lord, annexure P2.
No, there is alternative land that has been given, my lord, 38, I
Page
think.
47 is the LOA.
LOA.
Where is the LOA? Where
My
is
lord,
where is the schedule?
My lord, 40, my lord, kindly see, my lord, 40. Annexure P6. Category
40.
Page 40. Jail number, Tahsil number, everything is different.
No, it's correct. Where you are not mentioned in LOA. LOA, there is no survey number.
My lord, if your lordship can draw some
Page
assistance,
20.
French to 38, my lord, because there is a change of land, my lord.
That's why.
Yes, sir.
Now I want to see which area he offered to you.
Well, that page
No,
28 is
38 is
No, no.
page 28
Which
is
area he has offered to you for the which you have considered. Because you have inspected the then only issued the LOA. Where is the proposed land?
the alternative land we has offered is at page 38, my lord.
38.
Yes.
Alternative land.
This is the 40, my lord. Same.
$296. Ketan number 296, plot 1361, Ketan number 70, plot 22.
13.6. 13.62.
Where is the 296? 1361, 1362. But only 1361 is here.
Well,
There are two plots. There are two plots.
There are two plots. Plot number.
Plot 1 is the office and another is the go down, my lord. 1361 is the go down. This is the, my lord, their objection.
1361 and 1362.
Where it is a Birbhum.
Birbhum, my lord, Rampurat subdivision.
Okay. So can a special officer be appointed?
No, I don't have any.
My lord, let also the BLLRO be assist, my lord, because the distance has to be measured.
Yes, in presence of the VLLR,
Yes,
he will produce the document with
Yes,
regard
yes,
to the identification
Yes,
of the
my lord.
land.
Yes, my lord. Yes, my lord.
The special officer will issue notice
Yes, my
to the BLLRO
Yes.
to be present along with the record of the property
Yes.
so that the identification can be
My
made.
lord. Yes.
And identification
Yes.
is made and to see how many,
How-
what are the
distance.
surrounding in and around,
Yes,
what are the distances,
Yes,
if
my
there is school, college or hospital.
and it
whatever.
will, the topographical picture be brought before your lordship.
So that
My lord.
That will serve, my lord. That will serve everybody's purpose.
The petitioner has filed the present writ application with the grievance that the IOCL,
BPCL.
BPCL,
My lord.
the BPCL has issued letters of appointment for Bharat Gas Gramin LPG distributorships at location Prasadpur district, Birbhum, West Bengal, under category open marketing plan 2017-2018. Full stop. After acceptance of the letters of appointment, the petitioner has requested the Gram Panchayat for issuance of no objection certificate so that the petitioner can run his business of Bharat Gas Gramin LPG distributorships as per the letter of appointment issued by the BPCL. Counsel for the petitioner submitted in spite of several representation made to the respondent number 7, as well as the respondent number 4, 5 and 6, till date no objection has not been provided to the petitioner, due to which the petitioner is not in a position to operate the LPG distributorships in terms of the letter of appointment provided to the petitioner. Learned counsel appearing for the Panchayat submits that the place where the petitioner intends to set up the distributorships, LPG distributorships, is surrounded by a school and college. And if the Panchayat authority will provide NOC and no objection certificate to the petitioner for the purpose of LPG distributorship, and in future any untoward incidents will happen, the Panchayat will be responsible for the same. And as such, the Panchayat authorities are not providing the NOC certificate. The learned counsel for the BPCL submit that after the inspection of the property in question, the BPCL has issued the letter of appointment, but unless and until the petitioner will provide all the necessary documents or certificates from the concerned authority, it is not possible for the BPCL to allow the petitioner to run the said business. This court find that the only dispute in the police, the learned counsel for the petitioner denied the allegation made by the Panchayat authority that in and around of the property in question where the petitioner intending to establish the LPG distributorships consist of school and colleges. Full stop. This court find that the only dispute in the present application that the Panchayat is not providing the NOC no objection certificate to the petitioner due to the petitioner because in and around of the property in question, the schools and colleges are situated. Considering the submission made by the counsel for the respective parties, this court find that to adjudicate and this court find that whether there is any school or colleges in and around the plot being number the Ketan number 296/1, plot number 1361, and the Ketan number 724 and 890/1, plot number 1362, GL number 141, Muaza, Krishnapur, PS Nilhati, district Birbhum. There is any in around bola na? There is any school or colleges situated within the distance of How many meters is required? There's no guidelines. You are not having any guidelines.
Let the distance be detected.
What is the distance? 100 meter, 50 meters. School is situated.
Distance be
Any
detected.
school or college is situated in and around the set plot. According full stop. Who will be the who is the independent person not connected with both the parties? You. How many years practice you are having? 25. So you are not connected with any of the parties. Where you resides? Nadia. Where now you can go to the Birbhum? Calcutta. So you can go to the Birbhum. Okay. So what is your name? Sudeep? Sudeep Sarkar. An advocate having number. Which bar number? Which bar room? Advocate bar number 2 having phone number so and so is appointed as a special officer. As a special officer to inspect the Khetan, the survey number 1, inspect the aforesaid landed property and to ascertain whether in and around the aforesaid property is there in any college or schools are situated. If school, college or residential premises are situated. If the same is situated, what are the distance between the said land and the school, colleges or residential premises? Full stop. Full stop. At the time of inspection, comma, the special officer shall issue notice to the block development officer.
That is my lord the Nalhati block.
Block development officer, comma, Nalhati dash Roman 2 development block, as well as the subdivisional officer, Rampur Hat, to be present at the time of inspection of the premises in question. You will also present. You will issue notice to the block development officer, subdivisional officer, as well as the representative, as well as the respondent number
9, my lord. Bharat Petroleum.
As well as the respondent number 9 to be present.
Petition also.
To be present and the petitioner to be present at the time of inspection. At the time of inspection of the premises land in question. Full stop. The Pradhan also. Upar likho. Block development officer
7 and 8.
Respondent number 6, 7 and 8. 6, 7, 8. 8, 9. No. 6, 7, 8. 7 is who is Pradhan.
Yes.
8 is Sitala Gram Panchayat. What?
Panchayat as an authority.
There are 2 panchayat.
No, my lord. This is the Gram Panchayat and my lord another Pradhan, my lord of the Gram Panchayat.
5, 6, 7, 8, 9. As well as to the petitioner. Okay. 6, 7, 8 and 9 as well as to the petitioner for inspection and be conducted in presence of the respondent 6, 7, 8 and 9 and the respondent number 5 and 6 are directed to be present along with the record of the aforesaid landed property for the identification of the said landed property. For the identification of the said landed. The special officer is directed to submit report within a period of 4 weeks from date. Full stop. Let the matter appear on आज कितना तारीख है 29. Let the matter appear on 2nd September 2026 under the heading for orders. Under the heading for order for submission of the report by the special officer and further orders. The remuneration of the special officer is fixed rupees. Initially, is fixed rupees 1 lakh. Rupees 1 lakh. 50,000. 50,000, and the same shall be provided, and the same shall be paid by the petitioner.
point made based on a NOC granted by the earlier. That NOC is also already there at page 46 of
ऊपर
the
जब रेस्पोंडेंट बोला है ना, the land council for the BPCL submit that the allotment of LBG distributorship was allotted to the petitioner considering the earlier no objection granted by the Gram Panchayat.
Here no objection is not.
ठीक है सर.
I'm grateful.
I'm grateful, my lord.
Come with the report. $180.
This is a
Yes.
debarment challenge order, challenge to the debarment order.
Debarment.
Without the.
Come back with the deduction. As well as for universal, put on record. Immediate query was not why no hearing was granted. But things were not, they responded, kindly take page 246.
Petitioner.
The petitioner also the REC limited, but the hearing was not the REC may also.
Proposed action, তখন ডিপার্টমেন্ট হয়নি, এটা 27 মার্চের চিঠিতে।
But till the hearing is not given, this order will go.
Should not be given effect to. That is usual. That is.
So I am setting aside this, giving a lift.
Aside this order, the responses are already on record.
But I don't think whether the response is on record. If
Nothing
the
is on
lordship
record.
refers to 246, which my learned friend is referring to. Kindly
Suppose
see,
that-
I have given it to the executive director.
It has been given by you, Bindwala.
Yes, but it is not in relation to the
Debarment.
proposed action of debarment. I was not even informed. Kindly
So,
see.
Mr. Bilaskar, what I propose to do, subject to, I will set aside this. You issue the fresh so-called notice to both the parties. No, but this notice so-called has not been issued by them.
No, they have responded, but kindly take page 244.
Yes.
These were all addressed to the executive director.
দেখো এখানে ডিপার্টমেন্টের কথা কিছু বলাই নেই।
Because to the executive director of REC.
But this is not in relation to debarment. Your lordship will kindly see.
With regard to that they have came to know that they have cancelled the packages. That's why they've
Package
written that don't take action.
23 and 24 is the relevant package. We are not relying on anything with regard to that.
The kindly
তো হয়েছে পরে।
therefore advise WPC not to take any action if the
ফ্রেশ শোকজ আমাদের ফ্রেশ রিপ্লাই দেবো।
I will just.
No, that's correct. That's correct. But where is the notice issued that you are proposing the punishment of debarring?
Propose was issued to universal.
That's why. So this
Universal called for
correct. That's but this petition.
238 was the explanation.
Yes.
238.
Yes. The petitioner responds to universal.
238.
এইটা আমি ইউনিভার্সাল তো এটা পুট ফরওয়ার্ড করেনি।
Kindly see the date, my lord, 28th of January 2026. And what is the date of the show cause notice to universal? Kindly check, my lord. Fifteenth of January 2026, subject to correction. And that show cause is not given to me.
Yes.
That I will respond to that show cause.
Where is the so-cause? Where is the so-cause?
I don't have. I don't have. That my learned friend handed over to your lordship last day.
So-called notice was taken for 15th of January.
Yes.
আমাকে দেয়
20 January.
Universal has replied on 29th of January. Kindly note the date, my lord. Universal has replied to the show cause on 29th.
Okay, Universal are already replied that. So what I propose that the petitioner be give the reply to the so-called notice to you within a week to you, and give the personal hearing and pass appropriate order.
করতে পারবে না।
Because the Universal received that, but the petition not received.
For an explanation from them, they furnish their explanation on the basis whereof universal also were communicated the same to us.
Yes.
Universal's reply is before my reply to them.
20 January. Here is 28 January. No, you are 28 January. The so cause is 20 January. Kindly come to 238.
I find that.
The petitioner has filed the present writ application challenging the impugned order dated 8th of May 2026, wherein the respondent, Chief Engineer, who is the respondent number? Wherein the respondent number 2, has passed an order, by discontinuing the firm in all the power utilities, and country, and the utilities and what is that? What is? Because but it is not yeah, see, country. What is the word that it is not a proper? Page number 248, last two line. Discontinued in all power utilities and what is that? 248, last two, in such situation, last three lines. Prior to that, in such situation, utilities of the country. Pass an order. All powers, utilities, and of the country for a period of 5 years, including in power utility concern where this act is found. By the said order, the respondent number 2 has debarred the petitioner from supplying the materials for next 5 years. The main grievance of the petitioner by challenging the impugned order is that neither any so-called notice was issued to the petitioner, nor any personal hearing was provided to the petitioner. And without giving any opportunity of hearing, the respondent authorities have passed the impugned order by debarring the petitioner from supplying the materials for 5 years. Learned counsel appearing for the authorities has handed over the so-called notice and has submitted that before issuance of the impugned order, the so-called notice was issued and the reply has been filed, and after considering the reply, the impugned order is passed. The learned counsel appearing for the authorities handed over the copy of the so-called notice dated 21st of January 2026, wherein it is found that the so-called notice was issued to the Universal Map Projects and Engineering Service Limited, not to the petitioner hearing. Full stop. The Universal Map Project has already filed the reply to the said so-called notice. But the petitioner could not get any opportunity to file any reply as he has not received any so-called notice from the respondent authorities. Considering the above, the impugned order dated 5th of August 2026 is set aside and quashed. Full stop. Giving liberty to the respondent authorities if the respondent authorities is intending to proceed with the petitioner, proceed against the petitioner, the respondent shall provide an opportunity of hearing to the petitioner, and if any so-called notice is issued to the petitioner shall be at liberty to file reply within a week thereafter, and after receipt of the reply, if any, an opportunity of hearing should be provided to the petitioner and to pass appropriate order in accordance with law. REC, then you take, because here only the notice, why the REC will? What? REC is no, I have passed only order as he has not received. If you I have set aside, if you intending to proceed, you issue the so cause notice, first so cause notice, and to after giving an opportunity of hearing to pass appropriate order. I have not passed any order with regard to the REC now. Dispute. On the other side, 59 and 60. Yes. Hmm. Who is for the you or
No, I'm.
There already is online.
I wish I was there.
My lord, I am for government e-marketplace, my lord. In
Yes.
59 and 60, my lord.
Yes. Yes, where is that? Yes.
My lord, I am for the government e-marketplace, my lord. I think mentioning is, my lord, at the instance of ECL.
Though the matter is stated as item number 59 and 60, but the land council for the petition has mentioned the matter and submit that the interim order is still to and paid for extension of interim order. Have you issued the notice? No.
They have. But they have given me notice that they are going to mention at 150.
Yes, my lord, it is the ECL, my lord, who has, my lord, given the notice.
We will inform them.
In view of the submission made by the council for the petition, the interim order is extended. Yes. Interim order.
Kindly fix it on the second.
Huh?
Kindly fix it on the second half.
For?
তোমরা মেনশন করতে চাই নোটিশ দিয়েছিলে সেটাই বলছো
Notice দিয়েছো। Or is very back in the release plan.
What you want?
Kindly fix a date, man.
Is extended till 20th August 2026 or until further order, whichever is earlier. Let the matter appear on 6th August. 5th August. 5th August within 5 matters.
Lord,
Heading at John.
Lord, I'm grateful. Lord, but I'm extremely sorry. Lord, I'm very embarrassed also. Item 29, yesterday your lordship granted leave for within 10 matters because many matters were directed to appear within 10 matters, they have gone down as 29. Lord, can I bring my other side, Lord, at any time? Mr. Billodar Bhattacharya is appearing for the state, Learned Additional Advocate General. Could I bring them at 3 p.m., item 29?
3 p.m. original side.
3:30 or before
2 p.m. already. If the 2 p.m. matter is not taken, then I can may take.
My lord is already hard pressed. I understand, my lord. My lord is already under extreme lord pressure.
What can
Lord,
be done?
and could I bring them? So before original side at 3 p.m. if my lord allows.
No, that's why 2 p.m. क्या है? 2 p.m. में क्या number है?
It's watch 2 p.m.
Huh? 100? 80? 180? 179, 180 ना? कौन है इसमें? आएगा कोई? हाँ, वो तो होगा. I don't think the 2 p.m. matter will be adjourned. Seniors are there.
So before original side, if it could be accommodated for 5-10
Let
minutes.
us sit, take your chance.
Should I get, may I issue them a notice not for coming at 3 p.m.?
3
If my
p.m.
lord,
original side.
before original side, if
Original side is also, there is not
if
time.
5-10 minutes could be accommodated, Lord, only for that. Otherwise, I can't, Lord. I am
Okay,
already
come at 2:45.
Lord, and Lord, I apologize. I have taken much time on that matter.
No,
I
no,
was
that's
just
required.
concerned about the child.
See, some matters required.
Only I am doing my duty, and my lord has given me enough indulgence. So, Lord, I have
indulgence and other thing also.
That Lord, that's the blessings in disguise. That always comes. But that indulgence, Lord, allows us to, Lord, explore, Lord, the
See,
possibilities.
some matters required consideration.
Yes,
Malad, I
Required consideration, then
my lord.
it has to be heard.
My lord.
Malad, I
So, Lord, I'm giving you
45,
Lord, I'm extremely grateful.
245 will see.
203 number.
Malad, item
How,
11.
how much time will take?
Not much. I tell you, Mr. Joy,
Because 3 p.m.
by 3 p.m. it should be over.
Because other side I don't.
Otherwise, my lord keeps it on any other day, I think.
Malad, item 11, Malad, my learned other side is here. But very short matter, Malad, it will not take more than 2 minutes, Malad. Malad, SIR matter, name deleted.
But
Appeal
the SIR,
pending.
where is the election? You are referring?
Appeal pending, my lord. It's showing status as name removed for electoral roll, and in the meantime, my lord, I'm being harassed by the police also. My lord, there are no formal papers.
What do you want?
My lord, expeditious, at least expeditious. Hearing concluded.
Hearing concluded where?
Before the appellate tribunal.
Tribunal hearing concluded, not order not passed.
Not passed, my lord. My lord, page 66, my lord, will kindly come to.
Page?
Page 66, my lord. This is what the portal is showing. My lord, 65, the notice of
pending
appeal was there.
Pending on 5/4. But 12th
But
May.
at page 65, my lord will find. I was called upon on 12th of May. I have submitted all the document. Appeal was
12th May.
12th.
Yes.
That my lord will find at page 65.
Yes, 65 we have done the notice of 12th May. So what has happened to 12th May?
My lord, we have.
Whether this member is still there? Justice Bagh is there, or he already resigned?
Long time. But as per his.
My lord, acknowledgement of
So
the
what has
appeal
happened on that 12th May? What has happened?
My lord, I had submitted all the documents. My lord, that my lord will find at page 63. The acknowledgement is there.
So still there, it is pending.
It's pending, my lord.
So what do you want now?
Some expeditious order, my lord. Some expeditious order, because and in the meantime, what has happened, my lord? I've
See, if I pass an order, then I don't know.
My
You
lord,
are taking the risk.
What has happened, my lord? My lord, in the meantime, my lord, police is also.
If the court has already heard the matter, so any day to the order.
The tribunal, my lord, the tribunal.
Mention the matter. Why you are not mentioning the matter before the tribunal?
My lord, I cannot mean in the meantime, my lord, police is also harassing me, my lord.
That's correct. See, matter, it is not that your matter is pending. Your matter has already been heard.
Matter is heard,
judgment is to be delivered. You
Well,
do
reason
one
order.
thing because where is Ms. Pandey? So nodal officer has to be considered. You contact the nodal officer. You contact who is the nodal officer there?
জানি দেখিয়েছি ওটা
Because if I pass in order, then you will be in difficulty. I don't think what the appellate tribunal.
I understand.
Hearing is concluded.
Well, at least I may not be harassed in the meantime, my lord. That
I cannot.
My lord, as regard to this, my lord, nothing else, my lord. As regard to this,
police, then you go to the court number 5.
My lord, it is not just against police, my lord. In the meantime, my lord, this is remaining pending, my lord. Something, my lord, some order, my lord.
SIR I can pass, but you want I will pass an order. Then I will dispose of hearing now.
My lord, we'll do that.
The petitioner has filed the present date application on the ground that the being agreed and dissatisfied with the deletion of her or his.
Well, her.
Deletion of her name from the voter list. Comma, the petitioner have preferred an appeal before the appellate tribunal. The appellate tribunal has issued the notice on 6th of May 2026 for hearing on 12th of May 2026. On 12th of May 2026, the petitioner appeared before the tribunal and submitted all the documents, and the honorable tribunal has fixed the matter for orders. In the meantime, the police authorities are asking the petitioner, and as such, the petitioner has filed the present date application with prayer for a request upon the tribunal for disposal, for passing the appropriate for disposal of the appeal as early as possible. Consider the submission made by the counsel for the counsel appearing for the ECI submitted that the tribunal has already heard the petitioner and the petitioner has submitted documents, and the tribunal will pass appropriate order as early as possible. In view of the submission made by the counsel for the respective parties, the WPA 14999 of 2026 disposed of with the request to the appellate tribunal to pass appropriate order on the appeal filed by the petition as early as possible within a period of, preferably within a period of 2 weeks from the date of receipt.
I'm grateful.
Before your lordship rise, if your lordship
I'm-
kindly pardon me 1 minute. In the morning, I've seen your lordship. Only thing, my interim order will expire day after tomorrow, and
Day after tomorrow, give the number, it will come tomorrow, and mentioning that day after tomorrow, mentioning list.
can it be tomorrow, my lord? Tomorrow. Day after
we couldn't reach, but my lord, this petitioner
fixed
reached.
one matter.
Lordship had fixed at fifth, my lord, that matter. But I'm just intimating that because the tender process is entirely.
That's the fifth time I think within 5 matters.
That can be preponed on any.
Within 5 matters, I fixed it.
If can be preponed, my lord, that's my only request. That was my purpose of mentioning.
Other side,
I have given them notice. I have given another notice.
Where is the other side? Mr. Datto?
I have given them notice.
Okay, see if they bring any of the junior, I will fix.
Any other prepone, that's only.
Bring any of the junior.
I will request them to. ওদের কাউকে ডাকতে হবে খবর দাও ওদের কাউকে
There are two writ petitions. One, is the prior writ petition that was filed by the independent research. That is 20141. That is Mr. Mukherjee's writ petition.
20141.
Now, in that, Mr. Mukherjee had questioned an order passed by the FSAI, giving us a clean chit. And he said that this is not what can be done within the provisions of the Act. Now, after Mr. Mukherjee had made his submissions, the FSAI, who had already given me that clean chit, comes forward and issues a new notice, a new improvement notice. That was the subject matter of fresh challenge by me.
You challenge that.
So, these are the two writ petitions. Now, so far as the new notice is concerned, that is the notice that is now prevalent. So, I'll address your lordship on the new notice. Well, just to give you a lordship of brief background, the mark that we are concerned with, which is also the label of the product, is doctor's choice. Now, when we talk about doctor's choice, here, it has been used as a registered mark. It is now a registered trademark in use since 1997. Now, please bear in mind two things. That there has been no complaints received with regard to this mark as being misleading or ultimately giving a wrong impression. No member of the general public has ever come forward. Till 2022-2023 there was no dispute. It is in the year 2023 that a spate of complaints were made, and all these complaints were made by only one agency, independent research. These complaints were made with the trademarks authorities. They were made with the food safety standard authorities. They were made with the consumer protection authorities. Now, all these were duly answered, and ultimately satisfaction was received. Now, so far as this is concerned, if your lordship will now please see, so far as I will not trouble your lordship with now presently the registered marks. One thing is very important. If your lordship will kindly have a look at, first, page 67 of the writ petition. This is number.
Second writ petition.
Second writ petition. 29273. Page 67.
Yes.
Well, if your lordship will see, this is the Form C, which is the license issued under the FSS Act of 2006. Now, this license is issued to the petitioner, to the writ petitioner, Bajbaj Refineries, and kindly see the kind of business where it says that vegetable oil and processing units, and says it's a retailer, importer, etc., etc. Now, what this unit manufactured and still manufactures is various kinds of vegetable oil, and it does so with the brand name Doctor's Choice. And that has been the prevalent mark under which, my lord, these products have been marketed since 1997. Now, please see, my lord, this, my lord, license. Towards the bottom, your lordship will find issued on 12th January 2022, renewal license. Now, my lord, when they issue or renew this license to me on 12th January 2022, my lord, they are completely conscious of the fact that, my lord, I manufacture and, my lord, market my products under the brand name Doctor's Choice.
So you are the manufacturer.
I'm the manufacturer and also
Packers,
retailer.
traders, okay.
And now, my lord, please see, my lord, there's a product annexure, which of course is, my lord, not a part of this. My lord, please see. The product annexures is very important here. Next page is, my lord, your lordship will ignore. Please come to page 69. My lord, kindly see what are the products. My lord, number one is fats and oils and fat emulsions. And my lord, your lordship will find first is, my lord, the third column, cotton seed oil, binola ka tel. Then, my lord, refined salseed fat, refined palm kernel oil, interestified vegetable fat oil, refined groundnut oil, bakery shortening, refined soybean oil, refined sesame oil, refined rice bran oil, refined mahua oil, mustard, rapeseed oil, cottonseed oil, my lord, all the kinds of oils. And, my lord, so far as this is concerned, my lord, that, my lord, my brand name has been, my lord, Doctor's Choice, my lord, is not in dispute. So, my lord, when the license is renewed to me in the year 2022, it is renewed to me, my lord, with the knowledge that, my lord, I'm selling all these oils and, my lord, emulsified fats under the brand name Doctor's Choice.
So it is a Doctor's Choice.
Yes, my lord, Doctor's Choice. My lord, this your lordship will find from, my lord, my trademark registrations, which your lordship will find at page 79 onwards. My lord, your lordship will see, my lord, from page 79. My lord, item number one, it, my lord, Doctor's Choice. My lord, specification of goods and services to which is applied is, my lord, blended edible oils. My lord, your lordship has page 79.
Yes.
Now, my lord, if your lordship sees, my lord, this chart, serial number one, my lord, the trademark is Doctor's Choice. And your lordship will find the date of application is 2012, 18 July 2012. Date of use is since, my lord, 1st April 1999. And, my lord, the product specification services to which it's used is blended edible oil, dried and cooked fruits and vegetables, jellies, jams, etc., etc., etc. Now, my lord, similarly, if your lordship sees serial number two, my lord, again, Doctor's Choice. My lord, date of application is 1998. It was proposed to be used at that point of time. Well, this is rice bran oil included in class 29. Then, my lord, serial number 3, if your lordship sees, my lord, this is the packet, Doctor's Choice. My lord, this again, my lord, date of application is 2007, but, my lord, in use since 1999. This is in respect of mustard oil, teal oil, rice bran refined oil, sunflower refined oil, etc. My lord, similarly, my lord, item number 4, your lordship will find, my lord, again, my lord, blended edible oils, etc.
So these are the all items.
Yes. No, my lord, so therefore, what I'm trying to say, and, my lord, if your lordship sees, my lord, just one or two, my lord, items. Please see, my lord, now, page 80. Lordship will see pictorial representations. Kindly see, my lord, good heart. My lord, the implication is that this is good for your heart. Now, my lord, we are not making a medical claim. It is, my lord, ultimately a registered mark. Now, my lord,
good health is the registered mark.
A good heart. These are all registered trademarks. Good health. These are all label marks. Good health, good heart, etc., etc. Now, my lord, so far as trademarks are concerned, now, my lord, the trademarks is, my lord, something that is registered upon, my lord, the satisfaction of, my lord, the registrar, that it is not, my lord, capable of confusing or creating confusion. Well, I will not delve deeper into this because, my lord, your lordship is not really hearing, my lord, an action under the Trademarks Act. But, my lord, what is important is, my lord, here, my lord, I have been using this as, my lord, my trademark, my lord, right since 1997. And, my lord, there have been no complaints received, my lord, from any other source apart from this independent.
1990 and 1999.
1997, 1999, these are the use. Well, I have adopted the mark in 1997. That is what I have said. Well, that your lordship will find, my lord, is my lord my representation in paragraph 6 of the petition. My lord, and registration granted relates back to the date of use. Date of use is 1999, 1997. Well, it really makes no difference whether it's 97 or 99. But ultimately, what is important is your lordship has seen that it has, my lord, been used over decades. And well, naturally, my lord, when a mark has been applied and my lord, been in consistent use over decades, well, it acquires, my lord, goodwill and reputation. It acquires a market presence. Now, my lord, all of a sudden, in 2023, my lord, there's this frenetic, my lord, effort to ultimately, my lord, stop the use of this mark. My lord, how? By first making complaints to the trademark authorities, then making complaints to the consumer protection authorities, then making complaints to the FSSAI. Now, my lord, I'll come to the allegations. Now, my lord, what is very important is, my lord, FSSAI, till 2022, when they renewed my license, my lord, in respect of each of these brands, and my lord, full knowledge that, my lord, what is the brand name or my lord, label under which I'm selling, because that is within the purview of their, my lord, scrutiny. My lord, they, my lord, renewed the license without any objection. Now, my lord, so far as this is concerned, now, my lord, when, my lord, these complaints are made for the first time, my lord, let me show your lordship. My lord, what is, my lord, the first complaint that is made? If your lordship comes to page 373, 15th March 2023 is the first, my lord, notice that is served on me by the FSSAI.
73.
373.
Yes.
Now, my lord, this is an improvement notice issued under section 32 of the Food Safety and Standards Act. Now, my lord, may I just show your lordship what is the text of this? My lord, this will be important because I shall show your lordship as to how, my lord, these have been taken note of, how these have been considered and ultimately put to rest. And thereafter again reopened. It has been observed by this office that Bajbaj Refinery such and such is marketing on labels of refined soybean, refined sunflower oil and Kachi Ghani mustard oil with the brand name Doctor's Choice. Now, my lord, kindly mark the word with the brand name. Well, they recognize the fact that it's a brand name. With the brand name Doctor's Choice and pictorial representation of stethoscope on the label of the product is found to be in contravention of Food Standards Act of 2006 and rules and regulations. In this connection, you are hereby served this improvement notice under 32. Now, my lord, if this is a notice under 32, it's an improvement notice. So all that you're required to do is to improve on the label. Now, my lord, so far as this is concerned, now please see, my lord, what is the misleading and what is the ground for improvement? Please see, my lord, item number 2. It is observed from the front of the pack label that the brand name Doctor's Choice, along with heart symbol and stethoscope in the shape of heart on the label, are grossly misleading the consumer, as it ordinarily means that this oil is not only heart-friendly but also recommended by a doctor. This is in violation of sections 23 and 24 of the Food and Safety Standards Act 2006, Regulation 43 and 44 of the Food Safety and Standards Labeling and Display Regulations 2020. Well, there are several regulations under this act. Two regulations which are important are the labeling and display regulations and the advertising and claims regulations. Here the allegation is that this ultimately violates sections 23 and 24 of the Food Safety Standards Act and regulations 43 and 44 of the Food Safety Standards Labeling Display Regulations.
Yes.
These are thereafter reproduced. I shall take your lordship through the act together, not in a piecemeal manner. Then your lordships will see 3. In this regard, you are hereby directed to stop using the misleading brand name and pictorial representations on the front of the pack and label with immediate effect. Now, this is the first notice that was served. Now, so far as this is concerned, following very closely on the heels of this notice, this is 15th March 2023. They had also made a complaint with the Consumer Protection Authority. That your lordship will find at page 121. And that is a notice that we received from the Consumer Protection Authority under section 10A of the Consumer Protection Act. At page 121.
Yes.
Well, may I just read this? Whereas the Central Consumer Protection Authority has been established under Section 10(1) of the Consumer Protection Act to regulate matters relating to violation of consumer rights, unfair trade practices, false misleading advertisements, prejudicial to the interests of public and consumers, to promote, protect, and enforce rights of consumers as a class. Whereas Section 18(1) of the Act provides that the Central Authority shall, among others, ensure that no false or misleading advertisement is made of any goods or services, and to ensure that no person takes part in the publication of any advertisement which is false or misleading, and shall prevent unfair trade practices and ensure that no person engages himself in unfair trade practice. And whereas it has come to the notice of CCPA through a complaint received from Ingram against Bajaj refineries by the doctor's brand's choice, claim that edible oil is recommended and preferred by doctor, whereas such claim may misrepresent and mislead the consumers, as it is without any adequate substantiation and is a superlative claim. The advertisement was not substantiated with verifiable claim support. The advertisement is misleading by exaggeration and promoting the fried food under the name of healthy oil for heart, etc., etc. Then, my lord, further, it has been claimed that the product contains mufa and pufa, which keeps your heart healthy, but showed with visualization of fried food items, which is in question, as are also against FSSAI regulations. As under the FSSAI for soybean oil, certain claims are approved, but claims regarding healthy heart is not approved. Now, then it says, in relation to the above, advertisement also does not comply with, kindly now see they're talking about FSSAI regulations. Above advertisement also does not comply with Food Safety and Standards Advertising and Claims Regulation 2018. Now, my lord, this is very, very important. Please see, my lord, what they're saying is, my lord, they're relating into, my lord, regulation or rule 4.7.
Yes.
Kindly make a note of this. Rule 4.7, where the meaning of a trademark, brand name, or fancy name containing adjectives such as natural, fresh, pure, original, traditional, authentic, genuine, real, etc., appearing in the labeling, presentation, or advertising of a food is such that is likely to mislead consumer as to the nature of the food. In such cases, a disclaimer is not less than 3 mm size shall be given at appropriate place on the label stating that this is only a brand name or trademark and does not present its true nature. However, in the above mentioned advertisement, there is no such disclaimer for the brand name Doctor's Choice, and therefore may mislead the consumers at large and claimed as it is false claim in the advertisement. So, my lord, what are we saying here? My lord, the Consumer Protection Authority, my lord, is drawing a parallel from, my lord, the provisions of FSSAI Act and saying that, look, had you given this disclaimer, it would have been all right, because Section 4.7 says, Regulation 4.7 says that if today you're saying that something is pure, natural, etc., etc., well, anything that is misleading, well, how can it be cured? It can be cured by giving a disclaimer. And, my lord, what is the disclaimer? The disclaimer is that, my lord, ultimately, the disclaimer is that it is only a brand name. Now, my lord, so far as this is concerned, this is, my lord, the notice that is served on me. Now, my lord, so far as this is concerned, I give a response that your lordship will find at the very next page, page 123. Well, at page 123, this is my response of 14th April 2023.
143.
123.
Yes. Yes.
Well, please see, my lord, the third paragraph. With due respect, we would like to apprise of the fact that Bajaj Refineries Limited and its associated companies have been honestly using Doctor's Choice trademarks since 1999 in the commercial market without causing any confusion or deception and or misleading our present and potential customers. Here in Doctor's Choice, the goods is edible vegetable oil. The term or words Doctor's Choice, as is or in the manner represented in the subject marks, do not have any relevance to the goods described above. The said marks are distinctive and non-descriptive in nature and in no way convey an immediate idea of the kind, purpose, or other characteristic, or are misleading in any manner whatsoever. Further, please note, as per Food Safety and Standard Advertisement Claim Regulation 2006 and of the Food Safety Standards Labeling and Display Regulations, all Doctor's Choice product label have a disclaimer itself stating that Doctor's Choice is only a brand name and it does not represent its true nature. It is reiterated that the disclaimer on the product packaging labels dispels any scope of misconception, if at all, with respect to the nature of the product. However, in concurrence of the view of the Learned Commissioner, we are in the process of updating or editing our advertisements. The same declaration is being incorporated in an advertisement, which will be prominently reflected and visible to viewers. Then, my lord, copy of fresh advertisement, my lord, is then referred to. Regarding point number 4 in your notice, our response is that our advertisement, we have claimed that soybean oil is PUFA and MUFA enriched, which is approved by FSSAI as per the Food Safety and Standards Advertising and Claims Regulations 2018. They also approved the claim that PUFA ALA contributes to the maintenance of normal blood cholesterol levels, Annexure 2. From various research journals, it is accepted that maintaining normal cholesterol levels keeps the human heart healthy, as per Gazette such and such notification. Nutrient function claims and other function claims may be based on current relevant scientific substantiation and to provide scientific evidence on the type of claimed effect and relationship to health as recognized by generally accepted scientific view, etc. Still, then kindly see, still, to remove any confusion or ambiguity, we are in the process to incorporate the following recommendation in an advertisement. Doctor's Choice / BBRL recommends regular exercise and balanced diet for a healthy life. Experts encourage consumption of different cooking oils from time to time for better results. The images shown are for illustration purpose only and may not be an exact representation of the product. In the light of submissions, we request you to waive off the objection as raised. Now, my lord, after this, my lord, the CCPA, my lord, passes an order. Now, my lord, this order is important. Please see page 125.
Yes.
My lord, this is an order of 30th May 2024. My lord, these proceedings are, my lord, really happening parallel. My lord, the complaint raised
What
the
is the
following
date of the
issue.
order?
My lord, this is 30th May 2024, page 125. Yes. Now, my lord, please see. My lord, the complaint, paragraph 2, the complaint raised the following issues. In the advertisement, it has been claimed by the brand Doctor's Choice that the mentioned edible oil is recommended and preferred by the doctor, whereas such a claim is misrepresenting and misleading the consumers. Well, this claim was, of course, never made in so many words, but that was the complaint. The claims that the product contains MUFA PUFA, which keeps your heart healthy but showed with visualization of fried food items, is misleading. Advertisement represents that the Doctor's Choice oil product, along with visualization of the person in the dress of a doctor and promotion of consumption of edible oil without disclaimer. As per section 19(1) of the Consumer Protection Act, the central authority may, after receiving any information or
Mr. Shah, this court have a determination on this matter. Trademark, commercial. IP, because as per our rule.
Oh.
Yes, Mr. Mukherjee.
My lord, it's not a trademark matter, my lord.
It is not coming under the IP.
No, it's not.
Well,
it's not. It's under food safety, my lord. The entire thing.
I agree with my lord. I was for a moment, my lord, a little confused.
No, that's this.
No, my lord. I should have got on. My lord, this is not a trademark matter at all.
Yes.
Now, my lord, the complaint is, my lord, reproduced. My lord, first complaint is, my lord, Doctor's Choice, my lord, brand name.
Yes.
Is misleading, misrepresenting. And then, my lord, MUFA PUFA is not really, my lord, material. Then, my lord, 3 is advertisement represents Doctor's Choice oil product along with visualization of the person in the dress of a doctor and promotion of consumption of edible oil without any disclaimer. Now, my lord, kindly marks without any disclaimer. My lord, this is, my lord, what is important, because, my lord, what the authorities also recognize is that if it is accompanied by a disclaimer, then, my lord, it will be sufficiently clear to, my lord, the consuming public. Then, my lord, as per subsection 1 of section 19 of the Consumer Protection Act, the central authority may, after receiving any information or complaint or directions from the central government or of its own motion, conduct or cause to be conducted a preliminary inquiry as to whether there exists a prima facie case of violation of consumer rights or any unfair trade practice or any false or misleading advertisement by any person which is prejudicial to the public interest or the interests of the consumers. And then, my lord, please again see, notice is taken of section regulation 4.7 of the food safety. Now, my lord, I'll just read this once again. My lord, this is what the regulation says. Where the meaning of a trademark, my lord, this is very important, meaning of a trademark, brand name or fancy name, containing adjectives such as, my lord, this is not exhaustive, this is only illustrative, such as natural, fresh, pure, original, traditional, authentic, genuine, real, etc., appearing in the labeling, presentation, or advertising of a food is such that it is likely to mislead consumer as to the nature of the food. In such cases, a disclaimer in not less than 3 mm size shall be given at appropriate place on the label stating that this is only a brand name or trademark and does not represent its true nature. In view of the above, CCP observed that the alleged misleading advertisement published by the opposite party contained no such disclaimer for the brand name Doctor's Choice and therefore was misleading the consumers at large. No such disclaimer. So, my lord, disclaimer would sort out the problem. Given the above, the CCP issued a notice dated 3rd April 2023 to the opposite party to substantiate the following. Whether the edible oil is recommended and preferred by the doctor, advertisement by promoting fried food under the name of healthy oil for heart, product displayed as contain mufa pufa with the visualization of fried food items, no disclaimer for a brand name as per FSAI Regulations 2018, Regulation 4, Sub-Regulation 7. Opposite party submitted its response. My lord, I shall not read out the response. I have already shown you, Lordship. Now, my lord, please see, my lord, 7 Roman 3. My lord, this is, my lord, a part of the response. I will not read the entirety of it. Further, all Doctor's Choice product labels include a disclaimer stating that the name Doctor's Choice only represents the brand and not the true nature of the product, and stated that this is in accordance with the regulations set forth by the Food Safety and Standards Advertisement Claim Regulation 2006 and the Labeling and Display Regulations of 2020. The inclusion of the disclaimer on the product packaging ensures that there is no scope for any misconception about the nature of the product. However, the opposite party has updated / edited their advertisements and incorporated a declaration that will be prominently visible to viewers. A copy of the new advertisement is also shared with CCPA along with their response. Further, my lord, Mufa Pufa, I will not trouble your lordship. Then please come to Roman 8. Hence, based on the show cause notice, the opposite party will be incorporating the following recommendation in their advertisement to remove any confusion or ambiguity. And my lord, this recommendation is given. The recommendation includes regular exercise and a balanced diet for a healthy life, consumption of different cooking oils from time to time for better results, and a disclaimer that the images shown are for illustration purpose only and may not be an exact representation of the product. Then, my lord, opportunity of hearing was given, and my lord, written submissions were called for, written submissions made. I'll not trouble your lordship with that. Now, please see, my lord, paragraph 10.
Paragraph
10 at page, my lord, 129.
Yes.
As per subsection 2 of section 19 of the Act, where after preliminary inquiry the central authority has the opinion that the matter is to be dealt with by a regulator established under any other law for the time being in force, it may refer such matter to the concerned regulator. Now, so far as this is concerned, given the submissions made by the opposite party, a letter dated 16th June 2023 was sent to the Food Safety and Standards Authority to obtain their comments on the matter to enable CCPA to seek certain required information. Reply of FSSAI dated 6 July 2023 was received. Now, this is very, very important because ultimately the Consumer Protection Authority is proceeding on the basis of the reply received from FSSAI. As per Regulation 4, Sub-Regulation 7 of the FSS Advertising and Claims Regulations 2018, if a food business operator uses a brand name, trademark, or fancy name on a label or in the advertising of a food product, and that name contains adjectives such as natural, fresh, pure, original, traditional, authentic, genuine, or real, which could potentially mislead consumers about the actual nature of the food, then the FBO must include a clear disclaimer on the front of the product label. The disclaimer should state, this is only a brand name or trademark or fancy name and does not represent its true nature. Relevant one may be chosen as applicable. The purpose of this requirement is to prevent any confusion or incorrect impressions amongst consumers regarding the true characteristics of the food product. In this specific case, since the brand Doctor's Choice has been mentioned as a registered trademark, the FBO must ensure that appropriate disclaimer is prominently displayed on the label and all advertisements of the food products associated with this brand. This is very important because ultimately, the authority recognizes that I have a right to use my registered mark. Only I also have a corresponding duty to ensure that it is not misleading to the consumers.
So you have to
Put
make
that disclaimer.
Yes.
Print that disclaimer. And that was done. I'll show you, Lordship. Messrs. This is the response of the FSSAI. Bajbaj Refineries based in West Bengal is manufacturing edible oils in 4 variants. Doctor's Choice Kachi Ghani oil, Doctor's Choice sunflower oil, Doctor's Choice soybean oil, and Doctor's Choice rice bran oil. These products are being promoted on their official website as healthy, cholesterol-free, and unadulterated oils. However, it has been observed that these claims may be misleading and not in line with Schedule 2 of the FSSAI regulations. The FSSAI license, such and such, is the license under which Bajaj Refineries Limited operates. As per the regulations, any claims made by the company regarding their edible oils, health benefits, cholesterol-free nature, or lack of adulteration should comply with Schedule 2 of the FSSAI regulations. Under the terms like healthy, cholesterol-free, and unadulterated, without adhering to the specific guidelines laid out in Schedule 2, may create a misleading impression among consumers. It could imply that other products in the same category may contain high cholesterol or be adulterated, which may not necessarily be the case. FSSAI referred to the concerned Central Licensing Authority or designated officer with the request to scrutinize the matter further vis-à-vis the provisions of FSS advertising and claims regulations and direct the FBO to ensure that all claims should be made in line with Schedule 2. Well, I'll show you, Lordship, what Schedule 2 is of the said regulations, and the claims in violation of the same may be removed or withdrawn immediately. So, my lord, what has to be removed? Any claim which is in violation of Schedule 2. On 8th January 2024, a letter was sent to the FSSAI to inquire about the updated status of action taken by FSSAI against the opposite party in the present matter. In this regard, FSSAI has submitted the letter of 23rd January 2024 stating that the concerned licensing authority has issued the improvement notice dated 12th October 2023 to Bajbaj Refineries Limited and closed the case since the FBO has complied with the said notice and has removed all misleading claims from advertisements as well as from the label and has also submitted a copy of rectified labels. After receiving the inputs from FSSAI, an opportunity of hearing as per section 21 of the Act is provided to the opposite party, such and such. And these are the submissions that they make. May I read these submissions? You also will see Roman 1. As per the submissions made during the hearing on 3rd May 2023, the opposite party has withdrawn the alleged misleading advertisement from all media platforms. The opposite party is no longer making medical claims in their advertisements. The opposite party has now provided disclaimer as per FSS Advertising and Claims Regulations 2018 on all its products on primary packaging, secondary packaging, and also on its website. On examination, this is the result of the examination of all the material that is now brought forward. On examination of all the documents submitted by the opposite party, the FSAI response and the submissions made during the hearing, it is clear that. So, here they are really looking at what is the FSAI, because Consumer Protection Authority said that ultimately if it is the FSSAI regulations. So they call for response from FSSAI, look into the response, say what is the action taken, are you happy with it? They say the case is now closed, they have complied with all the regulations, and this is what it ultimately on examination of all the records produced, come to this conclusion.
Yes.
The opposite party was in violation of Regulation 4.7 of the Food Safety and Standards Advertising Claims Regulations and misled the consumers into believing that the edible oil products Doctor's Choice is recommended by medical professionals. Very, very important. So, the authorities, both FSSAI and the Consumer Protection Authority, they conclude that my advertisement, using the mark Doctor's Choice, is something that violated Regulation 4.7. The opposite party on receipt of notice dated 3rd April 2023 informed CCPA by its written submissions dated 3rd May 2023
Yes.
that they are providing the disclaimer Doctor's Choice is a brand and does not represent any recommendation of medical practitioner on all its packed products under the brand name Doctor's Choice, and the same has been incorporated in their advertisement. And the opposite party has validated the labels and disclaimers from FSSAI approved Equinox lab. So, these advertisements are now ultimately meet the requirements of FSSAI approved labs. From the above, CCPA observes that the opposite party has, within 1 month of receipt of notice dated 3rd April 2024, removed all the misleading advertisements representing the Doctor's Choice oil product, along with a visualization of the person in the dress of a doctor. Kindly see what has been done. Removed what? All misleading advertisements representing Doctor's Choice oil product, along with a visualization of the person in the dress of a doctor, and promotion of consumption of edible oil without any disclaimer from every media platform. So, what we remove is, stethoscope, doctor, white coat, everything is
Misleading
removed.
advertisement, the Doctor's Choice oil product with the visual doctor's dress of the doctor.
Yes.
And promotion of the consumption of edible oil without the disclaimer. Yes, in the media.
Whatever was without a disclaimer has been removed. Now, everything comes with a disclaimer. Further, Doctor's Choice is a brand name as a registered trademark having trademark number such and such, used by the opposite party since 1999. The CCPA observed the difference between the registered trademark submitted by the opposite party and the brand logo used by the opposite party on its products. Now, this is very important. There is a difference, this is what the authority accepts, between a registered trademark and a brand logo used on the products. In view of the above, a clarification may be sought from the Office of the Controller of General Patents, Designs and Trademarks and Internal Trade. On the action taken by FSSAI, the opposite party has modified its advertisement and label of its products as per Schedule 2 of the Advertising Claims Regulations. Whereas the CCPA is empowered under Section 21 of the Act to issue directions to the manufacturer of false or misleading advertisement to discontinue or modify the advertisement, and if necessary, it may by order impose a penalty which may extend to 10 lakhs and for every subsequent contravention may extend to 50 lakhs. In view of the above, the CCPA hereby issues the following directions. Budge Refineries Limited, with respect to its brand name Doctor's Choice, has to display a disclaimer in not less than 3 mm size at the appropriate place on the label, stating that this is only a brand name or trademark and does not represent its true nature, as required under Regulation 47 of the Food Safety Standards Advertising Claims Regulations 2018. Budge Refineries Limited will provide the above stated disclaimer clearly and visibly in the advertisement of its products with the brand name Doctor's Choice. If subsequent violation is found, a penalty of up to 50 lakhs will be imposed. This is the order that is passed by the CCPA. Now, my lord, so far as this is concerned, your lordship has seen that, my lord, this is something that, my lord, the CCPA, my lord, ultimately proceeded to pass upon observing as to what is, my lord, the requisite, my lord, provision of the regulations under the FSSAI Act, and, my lord, what was the stand taken by the FSSAI authorities. Now, my lord, while this was going on, a second improvement notice was served on me, my lord, that your lordship will find at page 377.
Have you challenged this notice?
Yes, yes. Well, this notice, the CCPA notice.
CCPA.
No, that is done. That is, my lord.
So you have complied with?
Yes, yes, we've complied.
So you're not agreed with this?
No, I'm not agreed with that. Well, I am only showing this that, my lord, ultimately the CCPA, my lord, takes into account all objections raised, all satisfactions, my lord, recorded by the FSSAI in, my lord, reaching its conclusion.
Yes.
And, my lord, whatever rules, my lord, Regulation 47 says, it says do the same thing.
Yes.
And also records that, my lord, we have complied with, my lord, the requirements of Schedule 2 of the Advertising and Claims Regulations. Now, my lord, this, my lord, order, this, my lord, improvement notice, by this notice by, my lord, the CCPA was served on 3rd April 2023. My lord, before that, my lord, the improvement notice by the FSSAI was served on 15th March. I've shown you a lot of that. So 15th March, FSSAI, then, my lord, 3rd April, CCPA. Now, my lord, while the proceedings before the CCPA are going on, my lord, a second improvement notice was served by the FSSAI that your lordship will find at page 377. Well, this is also under section 32. Now, my lord, what does it say again? Well, its subject is improvement notice
No, this
under
is of,
section
this is of 18 April 23.
18, but before that was 15th March.
That is the 15th March.
The 15th March, it was at page 373. Now, my lord, this is at page 377. I'm sorry. This is at page 110. I'm sorry.
Now 125. 125. What is the date of the 125?
Well,
This is 30th May. The 30th May 2024.
Yes, madam. 30th May. That's the order.
The order.
That's
Yes,
the order
order.
of the CCPA.
Yes. The order of the CCP was the 30th May.
Yes, madam.
And pendency, this notice was issued.
That's right.
Yes.
Now, my lord, so far as the 18th April notice is concerned, your lordship will find it, my lord, at several places. But my lord, since your lordship is, looking, my lord, at, your lordship will find it from, my lord, page 110 or page 377, my lord.
377, yes.
Yes, my lord. Now, my lord, so far as this is concerned, now, my lord, your lordship will see, my lord, again, my lord, this says improvement notice under section 32.
Yes. This was issued by the FCCA.
Yeah, FSSI. This is under 32. Then now, my lord, please see what it says once again. The reply received in response to the improvement notice dated 15th March 2023 is not found satisfactory. However, another opportunity is being provided and improvement notice is being served freshly upon section 32 of the FSAI Act of 2006. It is observed from the copies of the front of the pack labels enclosed in the reply submitted by Bajaj Refineries, having its office in such and such, with brand name Doctor's Choice and pictorial representation of stethoscope on labels on the product, which is found to be in contravention of Food Safety Standards Act, rules, regulations made thereunder. In this connection, you have hereby served the improvement notice under section 32 on the grounds mentioned above. Now, my lord, what are the grounds? Erroneous brand name Doctor's Choice and pictorial representation of stethoscope. My lord, these come together. Now, my lord, Doctor's Choice is a brand name, is my trademark. What is, my lord, really offending them is, my lord, the pictorial representation of stethoscope. It is observed from the front of the pack label enclosed in the reply submitted by Bajaj Refineries that the brand name Doctor's Choice, along with heart symbol and stethoscope in the shape of heart on the label, are grossly misleading. Misleading the consumer as it depicts the product is heart-friendly and recommended by doctors. This is in violation of Regulation 8.3 and 10.2 of the Food Safety and Standards Advertising Claims Regulations, thereby violating sections 23 and 24 of the Act. Now, my lord, so far as this is concerned, my lord, these, my lord, if your lordship sees, my lord, the stethoscope and the word Doctor's Choice, my lord, embedded within that, my lord, these are all our registered marks that your lordship will find from page 86. Now, my lord, these are the sections that are reproduced then. My lord, 2.2. It is observed that the labels of the products do not contain name of manufacturer and license number of brand owner not provided on the label. This is in violation of Regulation 5.6a and 7b of the Food Safety Standards Regulation. Well, these are reproduced. I should take your lordship through the regulations together. And then, my lord, if your lordship sees 3, mandatory requirement of compliance. In this regard, you are hereby directed to stop using the misleading brand name and pictorial representations on the front of the pack label with immediate effect. Taking cognizance of the above deficiencies and non-compliances, you are hereby directed to immediately comply with the said requirements and submit compliance report to this office with supporting evidence of action taken in the matter by you within 30 days. In case of non-submission of reply to this notice within specified time, this office will be compelled to initiate suitable action. Now, my lord, this is, my lord, 18th April 2023. Now, my lord, so far as this is concerned, my lord, your lordship will now, my lord, see, my lord, in the meantime, what happens? In the meantime, my lord, the order of, my lord, the CCPA, my lord, that is on 30th May 2024, my lord, is also, my lord, really under consideration because, my lord, responses are received. Now, my lord, then there is a third notice. My lord, the third notice is, my lord, 12th October 2023 that your lordship will find at, my lord, page 375.
375, 380. 375.
No, not 3rd October. My
Third
lord, this is,
Okay,
my lord,
there are two
yes,
places. It
it's
is.
12th October.
Yes.
12th October, my lord. 12th October is 375. My lord, here your lordship will see again, my lord, the third improvement notice under section 30.
Yes.
Now, my lord, what are the grounds here? My lord, please see misleading claims on official website of Bajaj Refineries. Now, my lord, it is misleading claim on official website only. It has been observed that Bajaj Refineries Limited is promoting its products on the official website as healthy, cholesterol-free and unadulterated oil. Usage of such terms also undermines the products of the same category available for consumers. The claims should be made in line with Schedule 2A of the above mentioned regulations. Other misleading claims found on the website include Thoda Tarka, Thoda Pyar and Aur Dil Ki Rakhe Khayal. Eat to your heart desire with oil that cares for your health. Add the joy of unadulterated oil. Lets your family win in the race of health. Cholesterol free keeps your heart healthy. And then, my lord, this is reproduced. Then, my lord, please see mandatory requirement of compliance. Then, my lord, before that, my lord, after the, my lord, portion, my lord, which is really in the nature of the advertisement, the above mentioned claims made for the purpose of advertisements are in contravention of regulations 4, sub-regulation 10, 8, 3, 10, 2, 10, 6, 10, 7 of the FSS advertising claims regulations. Hence, all such claims reflecting on your official website shall be removed with immediate effect. Now, my lord, we are now talking only of the official website, no longer talking about the label. Mandatory requirement of compliance. Taking cognizance of the above deficiencies or non-compliances, you are hereby directed to immediately comply with the said requirements and submit compliance report. So, my lord, now, my lord, the third, my lord, notice, as your lordship has seen, is, my lord, something that concerns only, my lord, the website. Now, my lord, these are the three notices that were, my lord, the subject matter of consideration. Now, my lord, what happens thereafter? My lord, if your lordship now sees, my lord, page 380.
380?
380.
Yes.
My lord, this is dated 12th October itself. Same date. Now, my lord, this is, my lord, a communication made by the Food Safety and Standards Authority, my lord, to the Director, Regulatory Compliance Division of FSSAI, New Delhi. My lord, this is what, my lord, is called an action taken report. Now, my lord, subject is action taken with respect to misleading advertisements.
It will take time, Mr. Soha.
Yes, sir.
Kal bhi hai?
Tomorrow, we also have tomorrow.
Come to me
Yes,
because other matter is fixed.
Yes, yes, ma'am. Of course. Of course.
Learned counsel for the petitioner in WPA 29273 of 2025 argued the matter at length, but due to paucity of time, hearing could not be completed. It is fine from the record. The matter is already fixed tomorrow at 2
Well, our interim order is still tomorrow.
Please the matter up
I'll
tomorrow.
make that submission tomorrow.
Tomorrow at 2 p.m. Yes.
Grateful.
Interim order is still tomorrow. No?
Yes.
कहाँ लगाएगा देखो.
No.
29.
I think the matter was mentioned before. Lord, the petitioner before Lordship is a journalist. Now, Lord, he was present in course of his regular discharge of regular duty in a rally, my lord, which was organized, my lord, on the 24th of July 2026. This rally was called by the Students' Federation of India and, my lord, the Cockroach Janata Party. It was in support of the NEET paper leak, which was, my lord, going on in Delhi. Now, my lord, what happened was that, my lord, the situation just went out of control. He was mercilessly beaten up by the antisocial elements who mingled, Lord, freely in the crowd. And Lord, as a result, he had to be hospitalized. Now, Lord, I believe, Lord, no permission was also given or taken from the state. Now, what happened, if your lordship, Lord, kindly sees the photographs, page 37 onwards, lordships will find that he was, Lord, surrounded suddenly while he was, Lord, recording the rally, reporting the rally. Lord, he was surrounded from page 37 onwards up to 47. The lordships will find he was surrounded, he was assaulted, and Lord, the hospital discharge certificate is at page, Lord, 48. We have, Lord, video recordings also. Lord, I am not, Lord, going into that. Lord, your lordships will find the discharge certificate at page 48 clearly records physical assault in a mob. And Lord, he was admitted on 24th and released on 26th. For 2 days, he was hospitalized. And Lord, with medication, CT scan, MRI, etc., Lord, all this is directed. Now, Lord, what I am on is, if your lordship kindly looks at my prayers, Lord, I want, Lord, government, Lord, should frame a comprehensive statutory framework or, Lord, a policy, uniform set guideline, Lord, where accountability of these parties who are, Lord, calling the meeting is fixed. Because, Lord, if this kind of vandalism happens, then, Lord, as a journalist, Lord, one can't just attend these rallies for the purpose of reporting. This is, Lord, absolutely, Lord, going contrary to the established practice that, Lord, I have a right, Lord, to go and report these rallies. Now, kindly come to prayer B of the petition, where, Lord, I am asking for a comprehensive either statutory framework or, Lord, guidelines, and it should be binding regulatory mechanism on these political parties or whoever, Lord, is calling a rally for the protest. And Lord, I am also, Lord, seeking a direction in terms of prayer E. If your lordships kindly look at prayer E. Lord, I have come to court, Lord, because I am seeking protection. Because, Lord, prayer E.
The FIR is not lodged.
FIR has been lodged. Lord, I must say that the state has, Lord, taken up the cause. There is a statement made in support of the journalist, Lord, who was beaten up. I was not the alone journalist. There are other journalists, Lord, who were also, Lord, similarly treated. But they were not, Lord, this was a students' agitation. They are not by the students. They are, Lord, by antisocial elements who, Lord, easily mingled with the crowd. And that will show, Lord, from page 37 onwards. Therefore, Lord, my FIR has been lodged. The state is looking into it. But, Lord, I want that I have given a list of media houses, Lord, the representative of whom were beaten up, page 12. Yes, page 12. Kindly come to page 11. Your lordships will find I have given a complete. Page 12, top. These are the persons, Lord, who have been assaulted. I am not alone. But, Lord, what I want as a collective protection, in so far as, Lord, the future rallies are concerned, and, Lord, in very strict steps, Lord, with regard to persons who were involved, Lord, in this. Because in this vandalism, because, Lord, I find that, Lord, the freedom of speech is a pillar of democracy. There's no doubt about it. But, Lord, through the media, this freedom of speech is expressed. So, my lord, if the media is affected, my lord, the whole infrastructure gets affected. So, my lord,
Yeah.
this is my prayer, and I say that
Prayer, what is your actual grievance?
grievance is, my lord, that I was
Framework
beaten up
uniform set the guidelines binding regulatory mechanism to governing the conduct of protest and rallies.
because, my lord, there should be a guideline. Whoever, my lord, is seeking permission from the government must know that these are the parameters they have to follow, including the controlling of antisocial elements being called in such meetings. And Lord, also, Lord, the second thing is that they must be held accountable and responsible. If there is vandalism, if there is, Lord, an untoward incident, indiscipline, that should be on account of the persons who are calling the rallies.
Government has not even given the permission.
And this, Lord, when the permission is granted by the government, they take note of certain, they put certain conditions. But Lord, where without permission, certain rallies are held. Then, Lord,
without permission, how the rally can be?
This is what we have come to learn. That, Lord, the last moment the permission was not granted. But Lord, the gathering
the
was.
permission was not there. How the rally has been
But the state is there. Your Lordship can ask the state. But Lord, this is what is happening. So therefore, Lord, a complete comprehensive guideline. I am saying that it has to be framed for the purpose of regulating the traffic, the general public. Lord, everybody's fundamental right gets affected if they go out of control.
On 22nd of December 2025, on a query from your Lordship, my lord, in a writ petition, WPA number 28912 of 2025, the state government, the then my lord,
whatever the state government
had intimated that it was informed by the learned counsel for the state that there is no guideline for issuance of permission for conducting rally public meeting by any person, including the political parties. Accordingly, the Director General of Police West Bengal as well as the Secretary Home of State of West Bengal are directed to submit a report with regard to what are the information documents which are required to be placed by the person to obtain permission who intends to conduct rally public meeting in public property of State of West Bengal. Well, may I just hand up a soft copy of the.
Yes, when Mr. Chakravarti has mentioned the matter, then I inform him. I had dealt with the matter, but thereafter I don't know where the matter
Point
has
is whether
gone.
the government has complied with it.
I had the occasion to represent the
Yes,
petitioner
yes,
in that matter, but the state kept on buying time. Thereafter, my lord, no report was filed.
Then the election
My
comes.
lord, the stand of the present government is, my lord, to make Calcutta a maximum city. So we are taking multifarious steps, my lord, for ensuring safety and security of the citizens, as well as, my lord, for ensuring or, my lord, infusing speed in the city, my lord, which is almost a necropolis now. My lord, we can, my lord, if my lord directs us, my lord, we can come up with a guideline. We can identify, my lord, designated places, my lord, within the city of Calcutta, in and around Calcutta, where only, my lord, these political meetings will be permitted, my lord. Otherwise, my lord, every now and then, my lord, there are writ petitions that we want to have it here, we want to have it there.
That's why on the last
That day, my lord, in fact, we even saw, my lord, procession of some form, in some form, my lord, by group of people, my lord, in front of the High Court. So it cannot happen because these are, my lord, perennial 144 zones. So, my lord, we can identify areas, my lord, earmarked for political rallies, my lord, or political meetings, my lord. And we can come up with a report as regards, my lord, the mechanism that the government will be adopting for getting up for people who will be applying. So we can do that, my lord. The report may also include, my lord, the guidelines, my lord, or, my lord, on the basis of the report, my lord can formulate the guidelines. That can also be done because if there is a gray area.
Input has come from the
Yes, I can come up with the
authorities
inputs
because
by way of a report.
CP and the CS and this Home Department file the report, file the report what steps they are taking, and thereafter will this court will find that if something is required or modification or anything, then it can be done, and if guidelines can be
Malad kindly
followed.
directs us, Malad, that. And Malad, in so far as Malad prayer E is concerned, if Malad directs us, Malad, we will also indicate, Malad, whatever steps, Malad, we have taken.
Yes, Mr.
Lord, the suggestion that has fallen from my lord from my learned friend and Lord, from my Lord, I think it is acceptable so far as we are concerned. We want Lord a protection so far as the future rallies are concerned. But Lord, if your Lordship so desires, your Lordship can leave it to the state also. But within a time-bound manner, this should be done.
Let they come within 3 weeks. Let they come the report.
And the other is Lord prayer. If your Lordship's Lord kindly Lord pass it an order in terms prayer.
We can also Lord file a report indicating
Prayer, let them file the report. What step they have taken? What is the stage of the investigation? Because
B and E, my lord.
what is the stage of investigation? What is there? It is not before the other court, and there is no other.
No, I don't know. This incident is of the 24th July, and I am not personally aggrieved because the petitioner is personally aggrieved. But in fact, there is an order passed by the Honorable Supreme Court where the Supreme Court said that you do not take coercive action against the student, but against the antisocial elements.
If you are not the student and not the student, they should not be released on bail and they take
That is
Separate the shaft from the grain, my lord, and indicate, my lord, who were the students, who were not the students, my lord.
The petitioner has filed the present writ application with the grievance for direction upon the respondents number 1, 2, 3 to formulate a comprehensive statutory framework from a uniform set of guidelines or binding regulatory mechanism governing the conduct of protest / rallies / public demonstrations / public gathering within the state of West Bengal. It is also the contention of the petitioners that the respondents number 1, 2, 3 should frame a comprehensive standard operation procedure within bracket SOP and guidelines for crowd management and the safety at rallies or public demonstration or public gathering within the state of West Bengal. The London Council for the petitioner further submitted that though the state has taken steps with regard to the incident of 22nd, 24th of July 2026, but the petitioner is also one of the victim of the said incident, and he has no knowledge about the steps taken by the authorities. London Council appearing for the state submit that the state has already initiated an FIR. Investigation is going on. In view of the above, before passing any further order, this court is of the view that the state should be given an opportunity to file their comprehensive report with regard to the comprehensive statutory framework uniform guidelines as well as the standard operation procedure. Who will only direct or who is the party here?
Lord, I want state. I am only against the state.
The directed the Home and Hill Affairs Department on the last occasion. The can direct the respondent number 2 or the respondent number 3, my lord. Either of them.
But the police authorities also is required.
No, it's essentially by the home.
Home, it is coming under the home. The respondent
Policy
number
has to be by the
respondent number 2 and 3 are directed to submit the report with regard to any steps taken by the state of West Bengal for framing of uniform guidelines or binding regulatory mechanism governing the conduct of protest or rallies or public demonstration or public gathering within the state of West Bengal, or any standard operation procedure has been framed, guidelines has been framed or not. The state is also directed to submit the report with regard to the action, with regard to the stage of the investigation of the incident of 24th of July 2026, wherein the petitioner is also the victim of the said incident. Let the report be filed within 3 weeks after serving the copy to the London Council for
Lord,
the
just one request, Lord. In the report that is going to be filed, let them also indicate, Lord, the routes of the rallies, because, Lord, that is also.
That time, whether any guidelines and SOP, if they said already there is a rule, they will indicate. They will not
Because,
indicate.
Lord, this has to be also, Lord, fixed. And Lord, kindly record, Lord, my submission that I am not against the students or their agitation. I am making it very clear. I am only against the antisocial elements.
It's also the specific case of the petitioner. Petitioner is not with regard to the any agitation any legible agitation by the people of the West Bengal, but he is only having the grievance that the state should fix the guidelines for conducting the rally or agitations in the state of West Bengal.
And blood, stop antisocial elements, blood,
Let
in
the matter of-
vandalizing the.
Let the
rally.
report be filed on 25th of August 2026. List the matter on 25th of August under the heading urgent motion within 10 matters.
I'm deeply obliged.
I can also in the meantime direct the state to ensure that without permission, there is no such repetition. We are competent enough, we are handling
But
it.
I tell your lordship, Lord, this protection is absolutely essential. They
That's
should
correct,
protect,
but-
Lord, they should protect the journalists, Lord, if there is a future, Lord, rally.
Let the
Otherwise,
report come. If it is not acceptable, then I'll give some interim relief, then we'll see to that.
My lord, today morning, my lord, I have, my lord, mentioned the item number 88 of
Yes.
interim order is, my lord, due to expire, my lord, today, my lord. And I have not already, my lord, served notice to Miss Banerjee.
Which matter?
Lord, item 88 of the monthly list, my lord.
Yes. So
Which for the other side?
My lord, state is, my lord, appearing, my lord, Miss Banerjee. I have,
You
my
are for
lord,
the petitioner?
yes, my lord.
88.
88 of the monthly list, my lord.
What is the name?
My lord, for your rescue,
For your
private limited
rescue.
versus state of West Bengal.
You are appearing.
I am for that other. Miss Sudhiba Banerjee is, my lord, appearing.
So the matter is, she was here.
Yes, my lord, she was here, my lord. She was here, I was.
The matter is appearing at item number 88 in the monthly list of this court. And due to paucity of time, the matter could not be taken up for hearing. And counsel for the petitioner has mentioned the matter and submitted the interim order is till today.
Today, my lord,
Till today
29th
and
of
paid
July.
for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 27th of August 2026 or until further order, whichever is allowed, let the matter remain in the list.
My lord, may I, my lord, make, my lord, one prayer, my lord. My lord, in this matter, your lordship would recall, article is to come from, my lord, Germany. 13 crores, 13 crores of stimulator, my lord.
Yes,
I have asked them for, my lord, inspection, my lord. They are not, my lord, coming for inspection, and delivery date, my lord, is within this month of August, my lord. They have to, my lord, take inspection, then, my lord, I can, my lord.
She made the submission on the last occasion.
My lord, that is in respect of another matter for which, my lord, interim order is expiring tomorrow. That I will mention tomorrow, my lord. But this matter also, my lord.
Yes, is there. I think so. Not there. Okay, let it come with the your other side, then we'll see to that.
My lord.
But,
Yes.
so far as the matter that I mentioned at 2 o'clock, my learned colleague is there, and your
Yes, ma'am.
petitioner's advocate, Mr. Dotto, is present virtually.
Yes,
I've given both of them notice. But, lordship.
I am for, my lord, government e-marketplace.
When it is fixed.
But, lordship petitioner is 6th, the 6th.
I am for the petitioner, my lord. It has already been fixed. They had given a notice. It was mentioned.
I mean, notice was given by me, but mentioned by them in my absence. So, I'm
No,
requesting.
no, they were present, my lord. My lord, remember, Mr. Poddar was also there, and Poddar was also there. He is there in the file.
For the 2 days,
It is fixed on 5th on next Wednesday.
Everything tender is finalized. I'm having it in my envelope. Only because of lordship's order, we are not publishing. And when the day finish the argument, only we have to reply.
So when you want?
So any other day prior to that, that's the
Prior to 6. 6 is not the good date to you.
it's a request that because lordship knows the authorities that they want it as
Push
fast
for
as
the other
possible.
side. Okay, then come on 4th.
4th not very good.
My lord.
तो कोरिदन कौन लिया सौरभ लिया ना 4th कर देना 6th का जगह 4th
On the within the first 10 minutes.
that is already recorded.
Lordship, may I be on item 50 of your today's lordship list. Interim order is expiring tomorrow, lordship.
Tomorrow?
Yes.
कल के do you mention कोरिदन?
Lordship, similarly, item number 176, interim order is expiring tomorrow.
Your Lordship, I appear on behalf of the respondents in this matter.
It will be listed tomorrow as to be mentioned. Yes.
176.
Yes, original side. Original side? Wait. It's the appellate side now.
Lordship,
Yes.
original site. Interim order is expiring tomorrow. It is appearing as item 176.
तो कल ऊपर कर दो, 2 आंसर में कर दो.
Much obliged, Lordship.
Yes, call the list.
My lord, item number 1, I appear for the petitioner. This matter has been wrongly filed before your lordship. This is a statutory appeal under section 49 of the Prohibition of Benami Property Transactions Act, and it should go before Justice Hiranmaya Bhattacharya. Inadvertently, it should go before the division bench because it's from the appellate tribunal. So it's been wrongly filed as a writ petition before your lordship. So I was praying if I could withdraw the writ petition and file it before the appropriate.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submit that the petitioner has wrongly filed the present writ application. Accordingly, prays for withdrawal of the present writ application with the liberty to file afresh before the appropriate court having determination. In view of the submission made by the counsel for the petitioner, WPO 345/2026 is dismissed as withdrawn with the liberty to file afresh before the appropriate court.
Grateful, dear lordship.
Well, your lordship will find 5 writ petitions in your lordship's list. We were addressing your lordship on 4/4 of 2024. 4/4. Toshniwal. Yes. So that from the papers of 4/4, since your lordship had considered 4/4 papers, in order for your lordship's convenience, we'll refer to the same. Because the documents in 4/4 are same in other 2 matters as well. So this will cover the other 2 matters as well. My lord, issue relates to willful defaulter. Showcase to same hi ache. What difference does it make? Well, I'll straight away. Well, I'll give your lordship a brief background, my lord, what had happened. Well, there have been a few previous rounds of writ petition and appeal. And then finally, my lord, the show cause notice, which is the subject matter of the writ, that was issued. So we'll straight away take your lordship to that show cause notice, which is the second show cause notice, which is at page 112. Your lordship will kindly make, your lordship can make a note. The company in respect of whom they are alleging willful default is a company by the name of EMC Limited. The first paragraph of the show cause, your lordship will see. It is addressed to 6 entities and my lord, first para EMC. EMC is in CIRP, subsequently in liquidation. Your lordship can also make a note that the EMC went into CIRP on 12th of November 2018.
Yes.
My lord, why I say this, my lord? There is a significance. If your lordship will see the show cause notice date.
January 9.
Yes, 2023. So 18, the company goes into CIRP. 19, 20, 21, 22, 23. 5 years thereafter, a show cause notice has been issued. One of the interesting aspect of the show cause notice your lordship will find Kindly turn to the second page.
Why you are telling this is second show cause notice?
The first show cause notice, my lord, what had happened is they had taken steps. There was a representation, then there was a writ petition by us.
Okay. Okay. Whatever.
Second writ petition, there was an appeal. Appeal, initially it was set aside. Appeal, they had taken another order. So, my lord, I am not bothering your lordship with all those orders because the issue is everything proceeded on the basis of the second show cause notice. So this is the show cause notice. If your lordship kindly turn to page 113, this is the second page of the show cause notice. Diversion of funds, which is 2.1.3b.
Yes.
My lord, our first contention before lordship is when you're talking about diversion, my lord, if I send the borrowed funds to another entity for the purpose of business, and if it is required for the purpose of business, then it does not qualify to be a diversion. Diversion would only under the master circular, it will only become diversion if it is for the purpose of other purposes, not for the purpose of which the loan was sanctioned. So here is the case, I'll show your lordship. All the funds that they are referring to are all for the purpose of business. And each of the event has been approved by the bank in their own appraisal note. Your lordship can also make a note of the fact that this is a consortium lending, of which State Bank of India was the lead bank. And the present bank, which is IDBI Bank, was a member of the consortium.
Who is appearing? Bank, nobody is appearing.
Now, my lord, kindly see the first event of default. This is under diversion, transferring. Now, my lord, I'm not bothering your lordship, my lord, with what they say. I just indicate, my lord, they say borrowed funds, transferring borrowed funds to subsidiaries, stroke group companies, or other corporates by whatever modalities. So, my lord, this is the 2.2.1c. This is the quoted portion of the master circular. Now, my lord, kindly see what they say on the particulars portion, which according to them, my lord, kind of fits into 2.2.1c. As per audited balance sheet of 2016-17, my lord, kindly make a note of this. 23 show cause notice referring to 16-17, and the company has gone into CIP in 2018. I just indicate the ex facie malafide of the bank. The company has made advances to its group companies, including their overseas subsidiaries. So I have made advances to my group companies and overseas subsidiaries. The details are given below. These are the, I'm not bothering your lordship with the entity name. Then, my lord, kindly see the remaining part of the first allegation. As per the audited balance sheet of the company for the financial year 17, the company had made investment of 47.82 crore in the aforesaid group companies, and promoter directors, my lord, kindly make a note of this, did not liquidate any of their investment. The allegation is factually incorrect. As per audited balance sheet of FY18, the investment in these group companies either showed an increase in investment in these companies or remained the same as per the previous balance sheet.
So these are the two allegations. Did not liquidate the investment, and the group company saw the increase, not
so
the increase.
Yes. So once they say 47 crore, I have invested in group companies.
Correct.
Now the first, let's examine whether investment is done or not. But kindly keep this and take my reply. I have given a reply to this show cause notice. My lord, your lordship will find the reply at page 123 of my lord, the writ petition itself. Same volume, my lord.
allegation. No, I'm not troubling your lordship with the background, my lord. Kindly straight away come to page 125. My lord, kindly take para 15. In your letter under such and such has committed the events of default. I have given 1, 2, 3, 4. My lord, I am dealing with one first. No, my lord, kindly take para 16. Regarding the first event of default, with respect to diversion of fund, for other purposes, I would like to clarify that there has been no occasion of diversion of working capital funds given by the lenders. Company has utilized the finance for the specific purpose it was given, and there has been no diversion of any funds disbursed by the lender for any other purposes. In any event, the allegations are vague and devoid of any material particular. Then, my lord, kindly come to the next page. My lord, then I give particulars and details of how I deal with this 47 crore. But your lordship will see the allegation in the show cause notice was investment made to group companies to the extent of 47 crore. Then, my lord, I'll deal with the 47 crore allegation. It has been alleged that as per the audited balance sheet of 16-17, company has made advances. So I've just quoted what they have said in the show cause. Then, my lord, kindly deal with the allegation. As per the audited balance sheet for the financial year 2017, the company had made investment of 47 crore in group companies and the promoters did not liquidate. So this is the allegation and how I deal with the allegation. It is specifically denied that the company made investment in a group. This is the immediately after that in any company by the name of Steel and Crane. So this is one factual correction we've made. Factually incorrect statement in the show cause. Then it is apparent that the committee has not gone through the details of the investment, such and such, non-application of mine. However, in order to substantiate the issue of show cause, complete application of mine. Then, my lord, kindly take the second bullet point, which is more like a hyphen. Investments are strategic in nature and in the similar line of activity of the company, mainly to expand business and better synergy in ordinary course of business. My lord, in the previous coordinate bench when the argument was made, so my learned friend's submission, the arguments had advanced for both sides. So, my lord, I take it into consideration that his arguments, at least on these aspects, will be the same. So he said this is Tharoorian language. So this doesn't change the situation or the synergy, expanding business, strategic in nature. It is irrelevant. Now, my lord, what we need to indicate to your lordship is that I am not a grocery store. I am not a trader by the roadside. Your lordship needs to examine, based on the nature of business, the quantum of the exposure, and what is the type of business I am engaged in.
What was the application for the loan? What loan you obtained for what? Business?
Yes. I have a global presence.
Correct.
I have businesses across. So that's what I wanted to show your lordship, my lord. Who am I? That is what I wanted to show your lordship. But this will have a material bearing on what we are saying. Well, kindly take once paragraph 2. I'll read it out for your lordship's convenience. Paragraph 2 of the writ petition. Para 3 of the writ petition. I just read it out for your lordship's consideration. EMC, the company, my lord, was engaged in the business of setting up electrical substation and installation of transmission and distribution network for power sector. So I work for power sector, public sector undertaking, which runs in each project runs into hundreds of crores. And railway electrification projects in India and elsewhere. The company executes project through special purpose vehicles
formed through joint ventures. Now, my lord, pausing here for a moment, these joint ventures are also with foreign companies, because otherwise I cannot do business in the other countries. And through subsidiaries, which is the common structure and arrangement scheme for the company engaged in engineering, procurement, and construction projects. This gives rise to, in the usual course of business, monetary transaction between company and its joint venture companies and subsidiaries. The company has been awarded Good Performance Award by the Power Grid Corporation of India Limited. So this is who I am, and I'll tell you, Lordship, my lord,
the transaction which they have issued the so-called notice, what transaction they have taken?
Well, there are multiple transactions. These I'll show you, Lordship. These are investments made in these companies, group companies, for the purpose of what? For the purpose of the projects that I was undertaking. And I'll show from the appraisal note, all were approved by the consortium of which he was a member. So these big loans, every year there is a appraisal that whether this sanction will continue in the next year or not. So at the appraisal, my lord, the company is required to provide the consortium all documents, all fund investments, all incomes, all receivables, on the basis of which, my lord, what should I say, my lord, a complete assessment is made by the bank. A holistical assessment is made by the bank, and then they either approve or they disapprove. Correct. So, my lord, I'll show your lordship. All of them is a part of my reply to the show cause itself.
So what the identification committee?
Nothing.
What is the?
They held nothing.
What is the?
They did not even consider any of my documents.
What is the finding of this reply?
I'll tell you, lordship. Kindly allow me to place, my lord, the last paragraph at page 126. Everything will become clear, my lord. The aforesaid investments, my lord, these investments which are on top, my lord. Yes. Crane, Kota, EMC, Saudi, EC West, DMCC, all these investments, we are talking about that. The aforesaid investments were all made over the period of years in ordinary course of business, with full notice and knowledge of the bank and the other consortium members. The investments were duly disclosed in the audited accounts of the respective years, which were submitted to lenders, including your bank, from time to time. Further, the same were analyzed and commented upon and accepted as reasonable in the numerous process notes finalized by lead bank, State Bank of India, and circulated with the consortium member banks, including your bank. Few of which are annexed herewith for your reference purpose. So I annex the appraisal notes of the banks. It is also a matter of record that these investments were deliberated upon at numerous consortium meetings and recorded in the approved minutes of the consortium meeting. You are kindly requested to refer to the minutes of the consortium meeting in your record for insight into the past information shared by the company and discussions held in various consortium meetings. Few of those relevant minutes of the meeting are attached herewith for your ready reference. The year-wise movement in such identified investments are analyzed. My lord, kindly make a note of how investments have come. From the period 2011-12 to 17-18, it is spanned over a period of almost 7-8 years. It is not, and my lord, now how do I say it is strategic? Now, my lord, kindly come to the last, towards the bottom of page 127, the last bullet point. All the above mentioned advances investments were duly discussed every year with the company in detail in order to incorporate the same in yearly appraisal notes. These appraisal notes were circulated every year
by State Bank of India to all consortium lenders, including IDBI Bank. For your reference purpose, below are the only few instances for the many wherein observations were made in appraisal note in regard to advanced investment made in group company. Now, I'll kindly see the observations that we've given. Well, all the appraisal notes is a part. So, this is the extract of the appraisal note itself. Well, appraisal note of 2050, next page. This is the extract that we gave in the reply to the show cause. There. Well, kindly see. Well, this is it is not my statement. I have extracted and quoted from the appraisal note. Appraisal note now, well, kindly, your lordship can take this and I'll straight away take your lordship to the appraisal note. One sentence, it will become clear. Well, kindly take this appraisal note of 1415 is at page 451. Kindly take that. One melod, one year, it will be sufficient. Or kunta we've given all of it. 451 ta kothay ache tatari bolo. 451 holo volume. Then, my lord, would it be your lordship pleasure to take 1516 because you're closer to that year, 1617. 1516 is at also at the same volume.
It starts at 370.
Appraisal.
And the relevant is 3.
Darav. Lordship kindly gives me a moment. It starts at 370, my lord. 370. I have to trouble your lordship one more time, my lord. It would be in volume 3. I just check the volume.
Volume 3, though?
Yes. Your lordship has it, but I don't. Yeah, page 370.
Page?
Mala 370.
Yes. Yes.
Your lordship will kindly first see page 373 once. So this is the appraisal note prepared by the consortium. I have no role to play apart from giving information, data, documents, audited balance sheets, my financial statements prepared by them. Well, if your lordship can see at page 370, the name of the company is given EMC Limited. Then the straight away your lordship kindly comes to page 373. Kindly see the brief background of the company.
Yes.
Well, kindly see the bottom of page 373. Well, kindly see, I haven't said this is what the bank is saying. So this is an answer to this strategic synergy. This according to them, these are all flowery phrases. No consequence. I haven't said this. Kindly see what the bank says. EMC is one of the leading modern power system companies in India. Its major clienteles include Power Grid Corporation of India. Kindly see the name. Andhra Pradesh Transmission, Maharashtra State Electricity, Central Organization of Railway Electrification, West Bengal State Electricity Distribution Company Limited. All public sector undertakings. Then, my lord, your lordship will kindly take the trouble in one. All of them do the same thing. My lord, kindly see my turnover. Kindly see the next page, top of the turnover. Well, it is unfortunate that one consortium lender has resorted to such malafide and arbitrary practice. Well, kindly have a look at my turnover. 3,609 crores was
Yes.
Now, my lord, kindly come to page 374, second last paragraph. In order to expand its activities, in diversified market. EMC has taken over 100% stake in Advanced Steel Crane Incorporation in USA. 70% stake in Technolines in Italy. ASC is a profit-making company founded in 1970, supplying transmission and substation structures in rural electrification corporation across USA and Canada. Technolines has significant international pre-qualification for EPC projects in extra high voltage transmission. This is how international business is done. And is now engaged turnkey execution of transmission line projects in Finland, Sweden, consortium with Aeon in Destia. Further expand its global presence, company has established 3 new subsidiaries in Dubai, Singapore, and Hong Kong.
Yes.
Dubai subsidiary is already in operation, and subsidiaries in Singapore and Hong Kong are expected to start shortly. And they say these investments made in the group company and subsidiaries are diversion. They may have a lack of understanding, but when I told you, you could have asked your consortium members, how did you approve this? And you're a party to this consortium lending. Then, my lord, kindly take at page 381. Kindly look at profitability.
Yes.
My lord, default doesn't give rise to actions under the master circular, willful default. My lord, the very object is the default has to be willful in nature.
That's why the willful default.
Correct. So I can be a defaulter, and I was a defaulter.
Otherwise, it could be a default notice.
The default notice happened. I am in insolvency, presently in liquidation, the company has gone. That is default. But as a matter of course, you cannot say that there was a willful default. I am trying to justify and defend willful default. There have been any willful default action. And this action is ex specie malafide, I'll show you, Lordship, but a controllable exercise of authority. Now, my lord, kindly have a look at the profitability. My EBITDA was 343 crores during 14-15 and have improved by 14% in comparison to the previous year. And then, my lord, kindly take the last paragraph.
14-15.
Yes.
Because notice of which year?
16-17. No, this is for the transactions that I...
Correct, 14-15.
Yes, possibly 16-17. This is 14-15. I'll show your lordship 16-17 as well. The year, in respect, the complaint in the show cause is for 16-17. I'll show your lordship 16-17 as well. My lord, I am trying to show, my lord, the previous year, then the subsequent year. So, my lord, this will have more material bearing on the subsequent year. So, my lord, I am trying to indicate to your lordship, my lord, this was consistent. Then market changed, we collapsed. So this was completely beyond our control. It was like a force majeure situation. Then, my lord, kindly take to the bottom of page 380. Hence, it is evident that EMC has performed comparatively better in comparison to the other major players in the industry. It contends that the same was possible only because of timely execution and thereby arresting the delays of subsequent cost escalation. I'll not trouble your lordship more, my lord. Kindly come to the next page at page 381. Now, the last 5 sentences of TNW. The last 5 sentences. However, only what is relevant for our purpose. However, EMC continues to invest into smaller units, both domestic and foreign, with similar business interest during 14-15, it contends that such investments are primarily made to obviate the possibilities of segment and revenue concentration. Some investments, the names are mentioned, were also made to facilitate penetration into railway segment where the company is expecting major revenue inflows in the midterm. Then, my lord, kindly come to 281 bottom. I stand corrected, 381 bottom. Roman 5. TW stood at such and such. Then, my lord, can you see the sentence starting? Though the ratio has improved over the years, but investment in subsidiary has increased from 17 crore in 14-15 to 71 crore in 2015, while loans and advance to related party decreased from 33 crores to 13 crore. So there is a net increase of 34 crores in the form of investment in subsidiaries taken into consideration. Now I'll show you, Lordship, the comment. This increase in investment in subsidiary is, kindly make a note of this, within the stipulation given by sanctioning authority during the time of last renewal.
Yes.
Due to infusion of fresh capital of 125 crores in the form of share application money, which has already been converted into equity, the company improved over the years, thus improving the ratio. Then it goes to plowback profit. Now, my lord, your lordship will kindly take page 383. And just on the investments in subsidiaries. Kindly take page 383. Just, my lord, before efficiency ratio, the paragraph which is before efficiency ratio, my lord, about 4 lines from the top, there is a sentence starting with the words, these investments. Is your lordship, does your lordship have that, my lord? These investments. What are investments? We are talking about investment in domestic and foreign subsidiaries. These investments are made in real businesses and very strategic. So it is not my word. It is the word which I have borrowed from the appraisal note of the bank. Strategic to activity. The investments made in associate subsidiaries are within the stipulation to be capped at 20% of cash accrual and additional equity brought in the company over and above 100 crores. Prescribed by the sanctioning authority. Some investments, name given, were also made to facilitate penetration in railways. Then, my lord, without much ado, my lord, straight away come to my lord, page 386. Roman 4. Change in investment in group companies and others.
Yes.
My lord, kindly see the last 4 sentences of this box. The first box on the right. Again, I am taught, it says, investor to be made such and such a company expecting major revenue. Then, to expand its business geographically and explore new markets, it had also formed new units such and such, Dubai, Hong Kong, such and such, with a total investment of such and such. Then, my lord, kindly take the last sentence at Roman 6. Kindly take the last sentence at Roman 6 at page 386.
Yes.
All these advances to its subsidiary companies are strategic in nature and in line with the stipulations made in the bank. Your lordship have that, my lord?
Yes, yes.
Well, last but not the least, my lord, page 387. Kindly take the comments. My lord, kindly take comments.
Yes.
Page 387. Kindly take, my lord, about 4 lines from the bottom of the comments. However, does your lordship have that,
Yes,
my lord?
yes.
Realization may not be a problem to the company as these debts are against Government of India undertaking state utility contracts only. Increase in investments in associate subsidiaries within the prescribed limit.
20% cash.
20% of cash accrual, such and such, stipulated by sanctioning authority during last renewal. And then, my lord, I have to trouble your lordship once with 388 because there is another allegation which is taken care of by this. My lord, only one sentence your lordship will see at page 388 before paragraph 13 starts, activity-wise cash flow analysis. My lord, kindly see the last sentence before that. The sentence before the paragraph 13 starts.
Yes. With increase in business.
Your lordship has that, my lord?
Yes, yes.
There is
No diversion of.
no diversion of short-term funds for long-term uses. The position may be considered as acceptable.
Yes.
And my lord, one of the parties, your lordship will find the name of the parties also here. If your lordship will see the show cause notice has reference to the party name. Show cause to kothay gela? Advance steel and print kothay gela? Now, your lordship will see, I can show you, lordship, my lord, I can tally one by one. It will take me a lot of time. Your lordship will see the investment that they have made in the chart, that these are the investments, 47 crore that they are complaining of.
Which,
In the show cause notice, that box.
Yes.
Each company investment is ratified. Now, one I can show your lordship, which I have right now, which has come to my hand, my lord. Kindly see at page 392. No, my lord, this is not this one, my lord. I'll give you a lordship. My lord. Not this one, my lord, not this one. Now, my lord, kindly take now, my lord, along with this same volume, my lord, kindly once take page 305.
Yes.
My lord, from this is the subject here, 1617.
Page
My lord, I am not troubling your lordship where it starts. I'll just show your lordship the one relevant paragraph. Kindly take page 308. At 308 bottom.
Yes.
My lord, what I read in the previous note, my lord, 1617, which is the subject disputed here, it has the same recording. Kindly see to 308. Bottom of 308, new management. Then 309, same. Wherever I have invested, your lordship will find the investment. McNally Bharat, lordship can make a note of McNally Bharat because one of their allegation in the show cause notice relates to investments made by us in McNally Bharat in the show cause.
Yes. So which page you are referring?
I have 309.
Yes.
If your lordship will kindly take. First, they are recording what I have done in the previous year, 9, everything. Kindly take the second paragraph.
Further company is stepping.
Yes, stepping ahead strongly with overseas business.
Hmm.
In international market. In the last year, company backed few international projects like transmission line project in Georgia of 150 crores, 55 crores, transmission in Bangladesh, 94 crores, refinery project in Oman of 1070 crores. In, Malat, kindly make a note of this, JV with McNally Bharat Engineering. Now, my lord, kindly take this and your lordship can make a note that there is an allegation that they have made that we've made immediately in the second page of the show cause notice where I stopped. The second allegation relates to loans and secured shares of other companies pledging of shares of McNally Bharat, in which EMC had invested their cash accruals. So what I'm trying to say is that this has been noted, approved in the approval. Since I'm in 1617, I'm showing your lordship, though I haven't gone to that allegation.
Yes.
So it says that 1070 crore of investment in a JV with McNally Bharat.
Correct.
So all approved, all these business transaction, investments, strategic, I have been approved. Then, my lord, I'll straight away come. But now, my lord, kindly come to paragraph 300, page 311. Kindly see paragraph 8. P11 para 8, details of intercompany transaction investment, if any, yes. My lord, kindly see this. Though the investments and loan advance in associate subsidiaries, JVs, as on 31st of March 2016 has increased by 26 crores. However, this is strategic in nature and considered acceptable. So this does not constitute a diversion within the meaning of 2.2.1c.
Yes.
Then similarly, my lord, if your lordship can see, this appraisal note continues at page. No, I have nothing marked in 325. Then, my lord, kindly take 325, top of 325.
Yes.
Loans and advances to group companies has increased, overall increase, is strategic in nature and is considered acceptable. Then others, EMC has strategic investment of 142 crores in McNally Bharat by availing long-term loan from IFCI Limited in order to gain substantial, my lord, kindly make a note of this, synergy benefits coupled with enhanced ability to provide integrated engineering electrical turnkey solution of the customers. And the comment is at page 328. Nice and corrected, my lord. 330, 330, 330. And if your lordship turns the page at 331, the first sentence. The conduct of the account is satisfactory with our bank. And lordship can also make a note of paragraph B at page 331, where they say the conduct of the business has been satisfactory with our bank. Then at B, they say defaults by any associate. There is no instance of default reported as far as conduct of foreign subsidiaries of the company is concerned. We have obtained opinion for all the foreign associate subsidiaries from DNB. Nothing adverse reported. Most of the domestic subsidiaries are having good or only current account with no borrowing arrangements.
Yes.
And after that, my lord, I get a willful defaulters notice alleging all the transactions which were approved, found strategic, approved by the approval note to be events of willful default. My lord, I understand that your lordship has a 345 fixed matter. I'll continue on the next occasion whenever it is convenient for your lordship, my lord.
Counsel for the petitioner. In WPA 424.
Yes, ma'am.
You have
No, my lord, all of them. In fact, my lord, this argument of mine will apply to 424, 424 and 425.
424 and 425, 2024. They will argue the matter. Argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter. कल है क्या?
That all the four matters may be kept together because earlier to Mr. Bose, Mr. Mukherjee had submitted and then so I can reply in one shot.
The moment we finish these two, we'll go to the another. There are two sets basically. This is the company set and then the other ones.
Other ones, Mr. Mukherjee has finished.
That already argued.
No.
Mr. Mukherjee has argued the matter.
Already
Not
argued.
no, that. No, don't say anything.
31st of August.
No, my lord, there are separate sets. My lord, the points are different. The ones where the points are common, I am addressing those.
Okay.
No date prior to 31st.
31st and 1st September, 345.
No date prior to 31st.
That is-
I understand, Miller. I am not saying anything. I understand Lordship's determination and how Lordship is. We only come for today. I am on respondent side, but it is just that because, my Lord, there is an interim order, my Lord. There is some.
See, I will.
He should be careful with his lookout matters.
No, I am always careful with my matters. That is why I am making the submission for an early date.
Yes. All that. Yes.
My lord, facts are a little unusual. My lord, there is a act which is called the IRBI Act, which is the Industrial Reconstruction Bank of India Act of 1984. My lord, this was pre-SURFACE and pre-DRT. So under that act, my lord, government used to be the Industrial Reconstruction Bank of India was a government entity. So there was a provision section 40 chilo na? Section 40 subsection 1, which authorized the bank in the case of default to invoke the jurisdiction of the High Court, writ jurisdiction, and ask for sale of the assets. So this application was made by IRBI Bank, and my lord, on that an order was passed in the year 1992, where receivers were appointed for the purpose of attaching the assets of the company. The company name was India Machinery, and for the purpose of sale of the assets of the India Machinery Company. Now, my lord, then India Machinery Company assets was attached. One asset of the India Machinery Company is a factory at Howrah, is a place called Dashnagar, Howrah. It's a 15.47 acres of land. Now, my lord, this land was attached and sold pursuant to orders of court. And there was an auction sale, and my clients, my lord, purchased the asset which included the immovable land, property, factory, sheds, plant, machinery, everything. Now, my lord, thereafter, pursuant to orders passed in the jurisdiction from time to time, my lord, the receivers who were appointed to sell, they were directed to execute a conveyance and make over possession. Otherwise, my lord, why will they sell it? Now, at the time of giving possession, it was found that there are multiple trespasses on the property, which may amount to almost close to 100 of them. Trespasses on the property. So when the receivers came, the application said that we are not being able to do it. So orders time to time. Receiver over the years have gone. Receivers have been subsequently changed, substituted. So the present receiver, we've given notice to him. Oh, my, yeah, Mr. Day is here, my lord. Mr. Day is the present receiver. Now, my lord, I'll just trouble your lordship with one order, which is of 21st of
What is
September.
the prayer here?
Now. Till date, I haven't got possession. So through the receiver, I want possession. Now, my lord, my good money. Now, my lord, what had happened? Why your lordship will say, what were you doing for all these years? I have an answer for that. My lord, section 6(3) of the Estate Acquisition Act. State government invoked section 6(3) and resumed the land. I challenged, resumption is not permissible. So the resumption order was finally set aside, division bench, Supreme Court. So finally we got the order, so that took about almost 15 years to reach the Supreme Court and get a dismissal of the state's appeal from the Estate Acquisition Act resumption from the Supreme Court. Thereafter, your lordship will be surprised to know, after dismissal by the Supreme Court, now state has filed a review application before the division bench asking for review. Be that as it may, that is still pending. Now now we have reconstructed the brief for the state because the state says that I don't have.
Self-given liberty?
No, nothing. So, my lord, who stops them from filing? But the question is that no order in the review. My lord, so, my lord, this has caused a delay. Now, my lord, what we are asking is, my lord, receiver has also, pursuant to the order of 2005, made publications, invited objections. And what capacity are you there in terms of the order? He is effectively, apart from one occupant, I understand that he has not received any response from any of the occupants. All ranked trespassers. So what we say is that it is the duty of the court to give me possession because I purchased it pursuant to orders of court. So, my lord, we need necessary directions from your lordship upon the receiver so that he can take steps, police help or do whatever to take possession and hand it over to me.
Whose possession is the whose property is this?
Trespassers.
Whose property is this?
My property. I am the owner. I show your lordship the conveyance. My lord, kindly take the conveyance which is at page 23.
So if it is your property and the public unauthorized occupants are there, so how this court?
I'll tell you, lordship, my lord. When the court is an act of court sold the property in auction. And
you purchased the property on auction?
Yes, from the court. That IRDBI sale.
Okay. You got the sale certificate?
Yes, of course. My lord, given by the receivers. That's at page 23. Page 23.
Which year you have purchased?
My lord, we have purchased in the year 2001. This is the irony, my lord, of court purchases. A person who purchases a property by paying his good money, today, my lord, it's been almost 24 years.
The bank is not now. The bank is
India Machinery Company was
no existence of this bank.
No. Now it has become Industrial Investment Bank of India, of course.
Sir, I would
in terms of the
one point here that this bank is currently under liquidation. This is basically IIBI. Basically, former it was this particular thing, and this is under liquidation. There's also a voluntary liquidation which is going on, and there's a liquidator who is appointed right now, taking charge of all the liabilities and assets and all. So once
so if it is in liquidation, the property is also in the liquidation.
No, this property is already
conveyed.
Back.
That's why it is sold.
Yeah, the liquidation state comprises of properties which are excluding this.
Correct.
Yeah, that's what they have.
Yes,
Actually, they have implemented us in this suit. That's the reason we are forced to come. Otherwise, we do not have any direct role in this.
The proceeding originally was initiated by them. Now, in all fairness, we had no other choice but to implement them. They have taken the money. I have paid them a settle. Now the question is that I am running from pillar to post because I have paid money and not getting possession.
Where is the property?
Howrah, Dashnagar, Howrah. It's a factory area, industrial area, factory industrial area.
And encroacher are private.
Trespassers, the encroachers. Total. Mostly, not total, but almost mostly. And over the years, your lordship can understand what has happened. And my lord, in fact, this is the reason, if your lordship can see once page 128, look, then it will become absolutely clear. I have seen the report of the receiver together with the sketch map. The receivers have indicated that some portions of the premises have been occupied by some persons. This is not clear under what authority they are in occupation. Therefore, I direct the joint receivers to cause notices are to be served upon the persons either by personal service or by affixation or by any other mode which may be deemed fit and proper to make the persons known about the proceeding pending before this court. The notices, however, shall be signed jointly by the receiver for the purpose of service and execution of the work. In any event, the joint receivers shall indicate in the notice that they are at liberty to approach this court, disclosing their right of occupation and status before the court, failing which it shall be presumed that they do not have any right, and appropriate lawful orders shall be passed by this court that this matter be based such and such.
2005.
Now, my lord,
2005.
yes, my lord. My lord, pursuant, then my lord, I went into resumption. I finally win the resumption battle in the Supreme Court, years together, 2 reported judgments. It's interesting. Jui finalis, this matter, the resumption matter, is a reported judgment, and this judgment today has been used in all resumption matters in against the state under section 6.3. One is Ratnagiri, and then came Jui finalis. Be that as it may, my lord, now if your lordship will kindly take, then the report of the receiver, which is at page 130. Just a page thereafter, your lordship will find the report, on the basis of which this order was passed.
So now what is your prayer?
No, my lord, my prayer is, now he has published 3 notices, newspaper, in terms of the order of 2005. Please come. My lord, now what we need is, my lord, police assistance if somebody comes in. Otherwise, my lord, they have to take possession, because without police assistance, receiver will never be able to take possession.
Yes. What about this receiver? So,
There is a list that he has prepared. Your lordship will find the
have you
list.
submitted the report?
Yes.
I can do that.
When you have conducted the inspection?
This letter which I had issued was in 2023. Thereafter, the paper publication also done in 2024.
Paper publication was made?
Yes.
So
3
thereafter
paper.
what has happened?
After paper publication, I haven't received any notice. But when I issued those letters, I had only 3 replies from 3
Occupiers.
They are basically not challenging the title. They are saying that we are staying here, these three independents, we have the title of this property. Let us put with the title. I can bring all those by filing the report.
So you do one thing now, when you file this writ application, the 26.
Yes.
You take further is publish a press notice. Publish a press notice, giving to.
My lord, I can affix those because most of the letters have returned back.
That's why publish the notice and the what it is the premises. There is a house, dwelling house.
No.
What is that? What is there?
Structures.
Structure, what they are doing with the structure if they are not residing. That's why shop rooms and all these things. So, and if there are no structure, you paste the notice.
Very good.
Fixing a date, the court is fixing
Correct.
the date of the court.
So in the notice, that date will be mentioned, that the matter is returnable in court on this particular
So
date.
that if any person they will come to the court.
Very well.
If they will not come to the court,
Correct.
correct. If they will not come to the court, then the court will pass appropriate order directing the SP of the area to give protection to you and take possession.
Very well. Very well.
That can be done.
Yes.
Yes, what is your?
My take is very, I mean, mixed up both actually. What happens is very
You
simple.
receive your money.
No, no, I do not have actually.
And went to and voluntary went to the IBC.
Yes, sir.
I know.
When voluntary went for the CIRP.
Voluntary.
Voluntary.
No, they have paid tax also. About 50 crores of tax has also been settled. So there should not be any problem. Voluntary means all the, I mean, corners are well covered, sir. Only the thing is that after.
The petitioner has filed the present application,
Thanks, sir.
praying for a direction upon the receiver to immediate take steps for removal of all unauthorized occupants from the property of the India Machinery Company Limited and to give possession of the said property to the petitioner. Now, an advocate appearing on behalf of the receiver submits that initially the receiver has published the notice and 3 replies have received by the receiver. Subsequently, none has come before the receiver claiming any claiming the right over the property. Counsel for the receiver submitted that this said notice was published in the year 2024, and subsequently there is no steps has been taken. Considering the above, this could find that the receiver is required to issue a fresh publication informing the occupier of the property in question either to vacate the property or to contact the receiver. And in the said notice, the date of this proceeding may also be indicated. If the occupier received the notice and intending to participate in the proceeding, the occupier can appear before this court and to participate in the said proceeding for proper adjudication of the present application. It is also made clear that apart from the publication of the notice, the receivers are also paste the notice of the premises in question if any premises are available in the property in question. And in the said notice also, the receiver shall inform that if any persons are intending claiming the said property shall contact the receiver or at liberty to appear in the proceeding on the date fixed. Full stop. The receiver is directed to publish the notice and paste the notice in the premises, if any, within a period of 4 weeks from date.
Well, one indulgence, when he is going to paste, he will face severe. So that's why I will not kindly give it. The concerned officer in charge of the police station will render assistance to the receiver for the purpose of pasting.
I will record. Yeah, within a 4 weeks. It is further made it clear that if the receiver faces any difficulty for pasting of the notices in the premises, the receiver is at liberty to approach the concerned officer in charge of the concerned police station, and if any request is made by the receiver, the concerned officer in charge of the police station shall provide appropriate police protection to the receiver for posting of the notice in the premises in question.
And my lord, only one more thing. Your lordship said that he will publish the notice. And my lord, kindly also indicate the persons will respond. They should indicate to the receiver in what capacity they are in possession.
Claiming any right.
Yes. In what capacity they are in possession. So that when they come to court, then
the report be filed.
Great.
Let the report be filed on 15 September 2026. Release the matter on 15 September under the heading orders.
Yes, yes, and my lord, only also, my lord, kindly include the remuneration of the loan receiver.
What was the remuneration earlier?
I don't know. Well, now your lordship,
Who will spend this money?
we will spend.
For the purpose of publication of notice and the pasting of notice and all.
I will bear the
miscellaneous charges
expenses.
Shall be borne by the petitioner, and the petitioner also directed to pay the remuneration of rupees 1 lakh to the petitioner for the aforesaid work.
Very well. 15th এর মধ্যে, and my lord, your lordship has made it returnable.
15th, kitna 15th na? 15th September.
Very well.
Sir, same time, sir.
Under the heading order.
কেন কি হলো 15th আবার কি হলো? সেপ্টেম্বর মাসেও আপনার অসুবিধে? এ ভগবান।
Puja.
My lord, kindly make it on the 17th.
17th.
I will not, I don't know when I live till 15th
Give the
September.
date in the notice and the publication.
17th of September.
September 17th. 17th September কিন্তু ইয়ে হয়, কি বলে, কি পুজো হয়, বিশ্বকর্মা পুজো। That's another problem.
17th is Vishwakarma.
21st, lordship keeps it on the 21st, Monday.
21st birthday.
21st. My lord, would it maintain the same time or will it be 3?
Orders.
For orders. Oh, obliged.
I have kept in mind.
Great.
Item number 8, well, I had finished my.
Yes.
I had made my submissions about this being an MSME, and I tried my best to distinguish that Swami Samath, that this is under the 16th circular, there is no need for.
When you receive the 13-2 notice.
Give me just one minute.
Who is for the, you are appearing
For the bank.
21st March 2024.
And before that, you have made any application for the revival package?
No, my lord, here, no.
When you made the application to the bank?
No, my lord, here, my submission was on the premise that, because this is mandatory as per pronits and as per the statute. If it's an MSME undertaking.
No, that is correct. But
No,
that's why.
no application.
Yesterday, I passed an order.
Because the lordship, I was told, I was seen the order, just now heard as I sat down. And this is the bad part. I just now said, he told me, I'm here to see the order. So that is a very disturbing part. But then, but I had submitted, lordship, can see that this is no, the requirement to apply is under the 15th circular.
Samarth.
Huh? Samarth, lordship, can you take a look at Samarth once?
Samarth.
Lordship, can you take a look at
And
Samarth?
your lordship judgment is also clear. Your lordship judgment is also clear.
Huh?
Your lordship judgment of Vitara, that is also clear. Visitsa.
Lordship. Visitsa, I have got the copy. Lordship kindly takes a look at the very first paragraph 2 of this judgment. This is clearly a 2015. I will just show my paragraph 2 of this judgment. I had given a copy.
Kindly come to the page, paragraph 7.
7 and 8. Lordship.
7, please see the 7.
As has been noted above, the petitioning enterprise does not seem to have claimed the benefit of the terms of the so and so of the lordship. Apropos this, lordship, I had shown this is 2015. Lordship kindly comes to that circular. Lordship sees page paragraph 2 of this judgment. Paragraph 2, the third, sixth. Yes, towards the middle, after around 7-8 lines. It does not appear from the petition filed on 14 July 25 that the petitioner enterprise objected to classification of its account as NPA, as well as issuance of the demand notice on the ground that the action of respondent number 2 was in violation of notification of 29th May 15.
Correct.
Now, should kindly seize 29th May 15 circular, which have you annexed here? Which is annexed here, my lord, page 104.
29th May 2015 circular, page 104.
Yes.
That is the requirement under paragraph 1,
Yes.
subparagraph 3 and 4.
Yes.
The application for initiation of proceedings under this framework shall be verified by an affidavit of authorized person. And 4, when such a request is received by lender, the account should be processed as SMAO and the committee under this framework should be formed immediately. So this is the triggering event of a MSME. But Lordship, kindly see this circular has been superseded for a category of MSMEs by the circular of 2016.
Yes.
That is page 110. Lordship kindly takes a look at from 10 lakhs to 25 lakhs, 10 crores, 10 lakhs to 25 crores has been taken out of the domain of the 15 and it has been brought under 16. Lordship kindly sees the paragraph 2.
Yes. But
While the prudential
continue
norm
to be as instruction consolidated 15 and as updated from
up to
time to
don't,
time.
yes.
The revival of
And is updated the revival and rehabilitation MSMEs having loan limits up to 25 crores.
Correct.
Will be in terms of these operating instructions.
Correct.
And these instructions, which expressly refer to the earlier one and supersede, kindly come to paragraph 1 and 2 here.
Of the
Paragraph, paragraph 2 here.
Of the 16.
16.
Yes.
That is page 112. It starts at page 110, which says it's only applicable up to 25 crores.
Correct.
And 16, here there is no such thing as applying with an affidavit for triggering the MSME committee. If you just compare the two, and if you see here, the committee has to be formed anyways. And the triggering event is something else. The triggering event is 4.1.
Correct.
4.1 is two circumstances. 4.1. Any, yes, 4.
Suitable consideration under the framework.
Application
The application
to the committee.
from Istas Enterprises. Kindly see 4.1. Any lender on identifying an
Lender means
MSME
bank.
account.
Lender means bank.
Correct.
Or identifying an MSME account as SMA2
Correct.
or suitable for consideration or as SMA2. The moment is SMA2.
Yes. Or
a receivable application. So either or. So either when it becomes SMA2.
That has been considered because the Pronit also consider it is also the duty of the petitioner and the bank, but the Pronit is considered if the representation is made to Now the Samarth kindly come to the paragraph 2. Paragraph 2.
That is in the context of 2015
circular.
2015 circular, this application is a must. Without that, because there is no obligation of the bank to on its own, lender on its own, to take the corrective action.
Correct.
If you just compare MSME 20.
But the Supreme Court, the contention of the Supreme Court is not that, okay, you slept over the matter, the entrepreneur slept over the matter, and the last moment you are coming with the bank with the representation that I am entitled for the MSME. That was the total object of the, as per the ratio of the judgment of the Supreme Court. Supreme Court's ratio that, yes, you cannot sit tight over the matter, being the MSME, and the last moment you can go and say that I am the MSME.
Please take a look at paragraph 5 of the Swami Samarth judgment.
Yes.
Paragraph 5. What about Swami Samarth?
The notification dealing with the framework.
That is 2015. More particularly, paragraph 1 and its sub-paragraphs.
Correct.
That's what I was showing at page 110 here.
Okay.
So, sorry, 112. That is, Lordship Kylie, that is 104. 104 is what the Supreme Court was looking at. That is why Lordship Kylie sees the language. In terms of subparagraph 2,
Correct.
Subparagraph 2 of what? Subparagraph 2 of
Identification by the enterprises. Subparagraph
Yes,
2
that
of
is of the
2015.
2015
Yes, 2015 subparagraph 2 is the identification
by the enterprise.
enterprise.
So that is sub, but I cannot apply under 2015 because my sanctioned loan is below 25 crores.
Correct.
So I have to go under 16.
Correct. Or your submission is that 16, so the quantum has been segregated, quantum of loan amount has been segregated, and or it is not and it is the obligation of both the parties.
And one more thing, Lordship, kindly see this as Supreme Court has noted. Lordship, the last 5 lines of paragraph 5, last sentence. For initiation of proceeding, paragraph 5 of the Swami, for initiation of proceedings under the framework, the application has to be verified by an affidavit of an authorized person.
Correct.
And upon receipt of request, that is paragraph 1, subparagraph 2 of 15 circular.
Correct.
Upon receipt of a request, the lending bank secured creditor is mandatorily bound to proceed in terms of and to constitute. That is not. That is conspicuously absent in the 16th circular. Paragraph. If you see the 16th circular, page 110, 112, that paragraph 1, subparagraph 2, there is nothing remotely comparable in this. So, so the other case which Lordship is talking about may have been a case where the loan was more than 25 crores. For MSME, but 25 crores plus. So in that case, it will be 1 subparagraph 2.
Limits about the 10 lakhs. To the committee for immediate meeting. Yes.
So, my lord, that is the distinction. So I cannot follow the procedure laid down in paragraph 5. But Lordship, maybe Lordship that this Bizitsa judgment, as my learned friend has referred to just now, kindly see paragraph 25.
Pardon me, it is marked.
It is his copy, but his paragraph. I have a clean copy also.
Visitor.
Bizitsa paragraph. Lordship, I have the SCC online printout. Paragraph 25.
Yes.
Mandatory part of the bank that in reply, if the borrower claims benefit of the framework with reasons and affidavit, the bank is bound looking. Because above this court finds that the proceeding initiated by the bank against the petitioner is the initial stage. Because here 34 possession has not been taken. There is no dispute that the petition number 1 is not an SM.
No, 34 has been taken.
Possession down. Possession down
has
is
been
not.
done. They have challenged
Possession is not taken.
They are
What is
taking
your position now?
Possession with me.
No, what is the stage?
34. They have filed section 17 in the year 2024.
Who?
They. And Milord, it is fixed a final hearing. They did not appear there. Milord, NCLT
that is neither.
Mr. You go tomorrow. Yesterday I passed the order. One matter, 2 judgments is passed.
Oh.
Mr. Kundu had appeared in the matter.
Why so late? That is
Since he's relying upon this Bridza judgment, or maybe I will take recourse to this judgment because there is no bar. I can even apply now today. Even I can apply today, Lordship. The petition.
There is no application.
Lordship, there also Bridza also, Lordship. Last 5 lines of paragraph 20.
When you file the application.
Nothing, not even today.
I will. Well, this was after the mother passed the order and then.
Nothing of this read. My learned senior friend is claiming that he is entitled to use it.
Lordship passed the order. Lordship, but it visits also they came without that. Lordship passed that order. So, and he relied upon Bizitsa.
Only 13.2 was issued, and thereafter they came to the writ petition. Here 13.4 was not issued. That is all distinction.
But I mentioned about the.
Everything has been mentioned in the writ petition, but nothing is there in not a.
Lordship, I must take a look at the judgment of my lord. But if he's
that judgment only I held. This court has held the similar. But the 13.2 issued, they have given the reply. In the reply also, they have not claim any benefit of the scheme. Thereafter, this possession with regard to the position was taken. They have not taken any step. They went to the court for the mediation. Then they filed the writ application.
Here in my reply to the 13 to 2, I have mentioned, of course, SMA and all, but so much as since my learned friend referred to Bizidza, she can pass an order on same lines, I will accept it.
Let me see. Let me see.
No, this was the order in their surface application last day.
It's surface.
17/7. Then what has happened thereafter?
Thereafter, it has been fixed, my lord. I think.
But that MSM, that surface proceeding is pending. That is covered by a division bench in that judgment. Balkoro. Manjula Chelur. Manjula Chelur. That can't be a ground, Lordship. I can come back tomorrow, Lordship, if it can be there, and I'll take a look at my Lord's judgment also. I'm sure
For the respective parties.
Lordship may be the same position because
let the matter appear tomorrow at the top.
But same position, but then I'll finish. Chelutta anbe Chelutta. একবার বল